everyone. I welcome you to the 10th International Conference on International Law, Issues and Challenges, organized by Indian Society of International Law. This session is on crime across borders, the challenges of international law in organized crimes. We have Professor B.T. Kaul as our chairperson for the session. Professor B.T. Kaul is a Supreme Court advocate. He was the chairperson of Delhi Judicial Academy. Sir was also the chairperson of Vivekananda School of Law and Legal Studies. Now I request Professor B.T. Kaul to start the session.
Welcome to this very important session. I think all of us are facing the heat of the crimes across the borders, and the many important issues, I think, which are being taken up today for the discussion. As we all know that what is holding the field at the international level is the United Nations Convention Against Transnational Organized Crime, which was adopted on 15th of November 2000 and came into force on 29th September 2003. It has three important protocols also, which are important because they deal with the specific aspects. Now, those are the protocol to prevent, suppress, and punish trafficking of persons, especially women and children. Then there's a protocol against smuggling of migrants by land, sea, and air. Then there's also a protocol against the illicit manufacturing of and trafficking of firearms, their parts and components and ammunition. Now, this is one that it has to be adopted domestically, and also there has to be cooperation at the international level. How far we have succeeded in implementing and achieving the purpose behind these convention and protocols is a matter, I think, that will be discussed by our friends. But I think this is one of the, I think, perhaps the major step. This convention is a major step at the international level to fight against the transnational organized crime and signifies the recognition of the member states of the seriousness of the problem posed by it, as well as the need to foster and enhance close international cooperation in order to tackle those problems. I think three important areas which have to be dealt with, I think the developments that need to be addressed. Of course, a lot of areas need to be dealt with, but I think what I could perceive as three important areas that need to be tackled is the drug trafficking. In fact, especially the synthetic drug trafficking, which has emerged as a major global crisis. We have also witnessed the explosion of the cyber crimes. People staying in Africa are committing crimes in India. And then we have also the problems about the environmental issues. And then the nexus between terrorism and organized crimes. How do we fight them? What are the frameworks that have been adopted by various countries? I think in India we have special legislation, Unlawful Prevention Activities Act. And also now, recently we have brought it also in the General Code. I do not know why we have this in the general law, special law, and then brought in the general law. Is it that the government wants to take away or abolish that special legislation and make it a part of the general law? But then the problems are many, because the safeguards that we have under the special legislations are not the safeguards available to them. Because still we continue with the presumption. Of course, in the special legislations we have the presumption of guilt, which has to be rebutted by the defense. But in general law we don't have that. So therefore there are two systems which are going to operate, and the prosecution has to decide whether the person should be prosecuted under the special legislations or he should be prosecuted under the uh, general law. Now, this is, I think, one of the most important dilemmas that we face in India today. And you had a special investigating machinery under the special legislations, while as under the general law there is no special legislation. Investigating agency, you have the general investigating agency which will be taking. I think that's another challenge that we'll face. And then we had under the special legislation special courts dealing with these issues, while as in the general law, I think they'll be tried by the general courts. Those are areas I think that also need to be looked at. But I think what is important is for us to see how this menace has grown over the period of time and has become a challenge at the international level, and all nations are facing heat of this organized crimes because it is easy way to make the money and at the suffering of the human being. I think Punjab is one of the examples we have seen, has been one of the states where the youth, which used to be the best working youth in the country and responsible for the green revolution in this country. And I think we have, because of this drug menace that has not been able to be controlled and had the patronage, I think, of the people in power also, has created havoc for that state. And I think the very important generation of the people in that country, I am told that it is also now emerging in Haryana, and I think it has emerged to some extent because of the terrorist activities in Jammu and Kashmir. I think that's another state which is facing this problem, and a lot of families are affected by it. So therefore these issues are very important issues to be dealt with. How do we deal with these issues? We have a galaxy of the scholars here who have come to participate and contribute to the topic and tell us the way out to deal with this issue. I think we have the first speaker who is online. I think we welcome him, Mr. Aniel Ballard Singh. He's a Dutch Ministry of Social Affairs. He is online. He will speak about the illegal immigration and use of crimmigration. Now that's a new term which we have come to deal with the immigration issues, which is emerging out of the organized crimes. I think we'll have Dr. Aniel to make his presentation to begin with.
Thank you very much. Thank you for the invitation. It's an honor to be here, at least online. I hope that you can hear me properly.
Very well, we can hear you, yes.
Okay, thank you. So I'll start with my presentation about illegal migration and the use of pre-migration.
Yes.
I think, first of all, it's important to notice the term of pre-migration. It's derived from the American professor Juliet Stumpf in 2006, who qualified pre-migration as the merger of criminal law with immigration law. And she defines the definition as pre-migration, which consists of the letter and practice of laws and politics at the intersection of criminal law and immigration law. Both legal areas deal with the concept of outsiders, but the problematic aspect in pre-migration is the illegal stay of migrants, in which the state has instruments to enforce the expulsion of illegal migrants from their territory. Now, in the European Union, we have a return directive, in which the aim of this directive is the return of illegal third country nationals to a third country. Therefore, the return directive is giving the states three instruments. First of all, a return decision. Secondly, an entry ban. And thirdly, immigration detention. In a return decision, the member state is stating to a person that he or she is qualified as an illegal third country national who has the obligation to leave the country. Secondly, an entry ban states that a person is not allowed to re-enter the European Union for a certain period. And with immigration detention, somebody is detained for a specific period in order to facilitate for the member state to enforce the expulsion. Enforcement by the member states allows the member states at least to use also criminal law. And that gives tension between, on the one hand, the effective return measures of the EU Return Directive versus the fundamental rights of the migrants. There are some principles. The enforcement of these instruments in the EU Return Directive are allowed with due respect to fundamental rights and the general principles of EU law. There are some limitations for the member states in order to avoid that such measures are used in an arbitrary way. The general principles to have to be dealt with are the principle of legality, the principle of legal certainty, the principle of effectiveness, and the principle of effective judicial protection. I think that some important conclusions can be drawn if we look at the practice and case law of the Court of Justice in the European Union. First of all, the return rates of illegal third country nationals to third countries is very low at this moment for several years. Only 17 to 22% of the illegal third country nationals are really returning back to their country of origin. So that means that the aim of the Return Directive is not successfully made. Secondly, member states must respect the fundamental rights of migrants with the application and enforcement of the Return Directive. The application of general principles of EU law have resulted in more legal protection for the migrant. Thirdly, the norms and grounds regarding to immigration detention leave very much discretion for the member states for their own application of this restrictive measure. Therefore, there is no uniform application of immigration detention in the EU member states, and therefore we see different forms of legal protection in the European Union. Fourthly, regarding to the enforcement of return decisions and entry bans by criminal law, it belongs to the competence of the member states, and therefore there is no uniform approach within the European Union, and therefore we have different legal protection for the migrants in the several states. The limitations in the case law of the Court of Justice regarding to the use of criminal law by the member states means that there has always been the priority to return instead of criminal sentences. And therefore, legally, the use of criminal law in the European Union is allowed in order to realize the return of illegal migrants. But the follow-up question is the use of criminal law desirable? Now, if we look at international reports, there are not much reports which show positive results that the use of criminal law leads to more return of illegal migrants. So therefore, more research is necessary. But therefore, there are two preconditions. Firstly, effectiveness of criminal measures must be necessary. And secondly, legal requirements are necessary for the migrants. The proper use of pre-migration requires that a good balance is struck between the fundamental rights protection of the migrant and effective measures of the state. Moreover, transparency of the legal rules will play an important role. So if we make a comparison with the situation in India and whether or not to use pre-migration, I think that we can see also movements of illegal migration from countries in which we can see that persons are staying illegally in India. For example, people coming illegally from Bangladesh. So therefore, I think we need amendment of the Indian legislation. For example, by introducing legal terms such as illegal migrants, obligations regarding to illegal migrants, for example, that they must return. Secondly, a measure could be in that perspective to straighten the borders with more control of the border police. Thirdly, security and illegal stay of migrants in India. There should be more investment in police control, which is essential, and more investment should be made in immigration authorities and also the judiciary. Fourthly, bilateral agreements should be drawn, for example, between India and Bangladesh, readmission of nationals staying illegally in the other country after the necessary verification. And in that perspective, assistance and advisory can be made, of course, from services from the UN nations, such as UNHCR or the International Organization for Migration, IOM. I think these are my important statements which I would like to make in my presentation. So I'd like to thank you for your attention, and I give the floor back to the president or chairman of this session. Thank you.
Will you be staying for the whole session, or you would like to answer the questions right now?
I don't know. I can stay the whole session. That's not a problem.
All right. I think we'll take the questions, because a very important question that you have raised is about India facing the illegal migration of people from the neighborhood, and how Indian state should deal with it. Is it important that we should try to secure the return of these people, or what is the purpose of the criminal law in a kind of a situation that we in this situation talk about? I think there may be some questions. I think if you're staying back, we'll love to have you in the end to answer some of the questions that our people who are participating in the organization, this seminar, are going to ask you questions on that. Some clarification that may be coming from you. I think we have the second speaker is Madam Vaishali Shonkar. She is from late Govindrao Vanjari College of Law, Nagpur. And she is going to deal with the menace of drug trafficking, and she's going to answer the questions. Rise in drug trafficking.
Trafficking of women.
All right. She's talking about trafficking of women for prostitution, an emerging issue in international law. I think it has always been an emerging issue in international law.
Okay, thank you. A very good morning to Honorable Chair, esteemed panelists, distinguished delegates, and the member of ISIL who are present here. The topic of my research article is Trafficking of Women for Prostitution, an Emerging Issue in International Law. Human trafficking is a significant global problem that affects the people every year. During the past decade, the problem of human trafficking, although not new, has been subject of reform legislation designed to combat it. This includes in a particular criminalization of phenomena and its active agent and enhanced rights and support for its victim. The most appropriate directions and other aspects should be taken into consideration in order to make such measures and protection truly effective. Firstly, the initiative and political strategies designed to combat trafficking, in a particular sex trafficking, had not met with any consensus of definition of this specific type of trafficking. Secondly, human trafficking being with it issue that cannot be ignored when formulating a legislative response, the control of state borders, the fight against trafficking, and the way in which each country deals with prostitution. Over the past decade, human trafficking has moved from the margin to the mainstream of international concern. The rapid development of comprehensive legal framework that comprises the international and regional treaties and as well as a broad range of soft laws instrument related to it. Trafficking has been a part of a public discourse for nearly 100 years as trafficking and forced prostitution triggered including sexual exploitation, forced labor, and domestic servitude. Victims are prone or enticed into a trafficking network by using coercive tactics and forced into exploitative situations against their will. As supply and demand factors foster the growing trafficking industry, factors of demand sides are cheap labor, expanding commercial sex industry development policies such as to promote tourism, temporary migrant workers, etc. Factors from supply side, poverty, inadequate education and employment opportunities which leads to economic disparities. Globalization, it opened the borders between the countries, leads to growing trafficking. Civil and military conflicts due to which it drives the people to flee from their country, encouraging cross-border trafficking. Erosion of family values due to which it persuades consumerism, encourage the sale of women. Remunerative business, it is highly profitable and getting monetary returns, and women get attracted towards the crime syndicate and other forms of exploitation. Weak law enforcement, the existing mechanism and measures to penalize the traffickers, exploitation to corrupt law enforcers and officials, due to which it is difficult to curb and meet the existing problems or challenges. The major issue is online trafficking and sexual exploitation, emerging and growing problem. The present scenario, millions of women and girls were facing unrivaled levels of sexual violence and exploitation via internet and digital technology also. In the absence of any rules and regulation use of such technology, the traffickers takes the undue advantage of tools to exploit the weaker group with the help of digital technology and internet access that has completely changed the method of trafficking for buyer and the seller, and growth in sexual abuses and exploitation at global level. To address and identify these new dimensions of trafficking and exploitation through internet by framing the rules and regulations and making the internet safer for women and girls. CEDAW committee expressly calls for social media and messaging platform companies to be held responsible for their role in exposing women and girls as a user of their services to trafficking and sexual exploitation. Even it requires global cooperation to deal with multi-jurisdictional nature of online sex trafficking and sexual exploitation. There are certain strategies and policies for combating trafficking. States are under binding obligation to protect and respect the dignity of human being, which is a cornerstone of international human rights law. States must ensure that they work towards elimination of prostitution and protection of its victim by framing strategies for combating trafficking. For combating trafficking in women, it requires multidisciplinary approach, cross-sectorial approach involving governmental agencies, NGOs together with international committees and civil societies along with international standards and guiding principles such as control and suppression of prostitution only through legal system, rehabilitation and rescue of trafficking victims, demand for effective mechanism for protection and awareness amongst women and girls to prevent trafficking, develop effective regional and international cooperation against trafficking, non-punishing trafficking victims. There are certain principles for the implementation of these strategies that are responsibility of government, participation of civil society, human rights-based approach, interdisciplinary cross-sectorial approach. The states and international organizations promote the adoption of those policy, repeal all forms of criminalization of prostitution persons and victims of trafficking, criminalize all forms of peeping, procuring trafficking and trafficking of human beings, develop programs that provide access to justice, basic human rights, protection of victims and prostituted persons, criminalize all the purchasing of sex, develop policies for prevention. There are certain international legal framework with this respect. The most important international instrument to combat trafficking is Palermo Protocol, a supplement to the United Nations Convention Against Transnational Organized Crime 2000. Article 5 of this protocol requires states to criminalize trafficking and attempt trafficking and any other international participation or organization in the trafficking. On the other hand, protocol criminal justice framework does not include any binding provisions to protect the human rights and trafficked person. Two international labor organization convention focused on forced labor or services. The ILO Forced Labor Convention, Convention number 92 of 1930, which contains the definition of forced labor and provides that it should be punished as a crime, and ILO abolished a Forced Labor Convention number 105 of 1957. The Slavery Convention 1926 defined slavery, and its supplementary convention contains practice similar to a slavery, including debt bondage and institution and practices that discriminate against women in the context of marriage also. The United Convention for Suppression of Traffic in a Person and of Exploitation of Prostitution of Others in 1949 requires to punish any person who exploit the prostitution of another. The International Covenant on Civil and Political Rights prohibits a number of practices directly related to trafficking, including slavery, the slave trade, servitude, and the forced labor. The Convention on Elimination of All Forms of Discrimination Against Women requires states to take all appropriate measures to suppress all forms of trafficking in a woman and exploitation of prostitution of women. The general recommendation of number 19 identified trafficking as a form of violence against women because it puts women at special risk of violence and abuses. So I conclude my article with this remark: the existing laws has to be replaced by new comprehensive law that cover all forms of trafficking. There is a need to provide clear and comprehensive definition of all forms of trafficking, which is missing from the present act. The definition should lay emphasis on exploitation, which could be physical, sexual, or emotional. Instead of legalizing prostitution, the state should seek to create an alternative livelihood for sex workers and sternly punish those who exploit them with the objective of financial gain. Lack of concrete international anti-trafficking measure is practically unimaginable even the transitional nature of human trafficking. Protocol overemphasize the criminalized aspects of trafficking and relegates the rights and needs of women to subordinate position in the international legal framework. In recent years, due to great international pressure in this area, various governments have sought to develop strategies to combat the trafficking of people in general and women in particular. In-depth debate is necessary on the subject of consent, sexual slavery, and all forms of extreme exploitation to which female prostitutes may be subjected undoubtedly represent situations of suffering. While the international norms are clear, gaps still exist in the implementation. Although Palermo Protocol calls for comprehensive approach to combat trafficking, this approach has not been fully realized. Oftentimes, states attempt to address trafficking from only an immigration perspective or from a solely criminal perspective. State must recognize and implement all the international instruments to combat trafficking in order to ensure that problem is dealt with to fullest extent possible. A human right-based approach to addressing trafficking gives equal attention to prevention, protection, and prosecution. This victim-centric approach requires collaboration between legislator, prosecutors, law enforcement, service provider, and other victims advocates. Moreover, the new dimension of trafficking and exploitation through internet and technology need to be addressed. efforts. Thank you so much to the organizing team for giving me the opportunity for sharing my views on this topic. Thank you so much.
Important issues that have been dealt with is one of the, I think, important causes that he said: poverty, ignorance, illiteracy, and the exploitation of the vulnerable sections of the society by those people who are engaged in this kind of organized criminal activity. Then collaboration at transnational levels is very important, and development of the victim-centric approach is equally important. Thank you very much. We have now Mr. Abhinav Malhotra from Jindal Law School.
No, Leena, ma'am.
Oh, sorry. Leena, it's very small, huh? Leena Lal Langde from Nagpur, right?
Yes.
Rise in drug trafficking, a treat to international security.
Threat to international security.
It must be threat.
Yes.
I thought, how can it be a treat?
There is a spelling mistake. A very warm good morning to all.
How is it typed, wrongly? How can ISIL do it?
Clerical.
They are giving it as a treat.
It can make a difference.
Both of them are out to do.
Okay. A very warm good morning to all respected dignitaries, BT Cole sir, panelist of this session, and dear participant. I am Dr. Leena Langde, and I am presenting on the topic Rise in Drug Trafficking, a Threat to International Security. In recent time, the drugs trafficking is the most prevalent crime in organized crime in all over the world. So, first of all, we will say what is the drug trafficking. That is, the drug trafficking refers to a broad range of the offenses related to the manufacturing, importation, smuggling, cultivation, and promotion of these psychotropic and narcotic drugs, and even includes the transportation of this drug. Drug trafficking is the serious issue that poses a serious threat to the public safety and the health, as well as it affects the national and the international peace and security. Drug trafficking is a tempting alternative for the surviving financially in the many regions of the world. There are the many causes like the poverty and unemployment and the financial gain also. And I can state the one of the example, that is the Colombia, which is in the country of the Colombia, the large number of the people turn to the drug abuse and the trade as a means of the escaping their extreme poverty. Today, narcotic drugs in high demand, which fuels the trafficking network. Latin America has been a key player in the various global illegal drug market in the last few years. Many parts of the drug supply chain occurs in this region, such as the growing drug crop, producing drugs, trafficking them, and finally using them. South America has held the title of the biggest cocaine producer for the worldwide market. Opium and heroin dominate the drugs in Asia. Now, when we talk about India has become both a transit and a destination country for the heroin and the hashish produced in the Golden Triangle and the Golden Crescent. These substances and the drugs are being trafficked illegally in both the directions, which not only breaches the Indian border but also seriously jeopardizes and national security. The relationship between the terrorist, organized crime, and the drug traffickers had produced a force strong enough to destabilize the nation. Drug-related revenue has been utilized to support a number of the terrorist and insurgent organizations. We all know that now India becomes the first largest populated country in the world. Due to vast population, India is the hub for the drug traffickers. In spite of these, there are several reasons due to which the drug trafficking is the prevalent crime in India. The first reason is that India's geographical location is in between the Golden Crescent and the Golden Triangle region. This region considered as the most drug producing area, therefore it makes more vulnerable for the drug trafficking. For example, in the area of the Crescent, drugs like opium, heroin and hashish are manufactured by Pakistan, Afghanistan, Iran and smuggled into the India through the northwest border. Second reason is due to the large number of the population, there is a highly demanding of the drugs for the recreational and the medicinal purposes. Third reason is that India is having the porous border that it shares with the border of the several countries and mostly vulnerable for the drug trafficking for the smugglers. In India, corruption is one of the major cause for the drug abuse. Another reason is the lack of the awareness among the people about the use and the effect of the dangerous drugs. Young generation always put on the risks of using drugs and also indulge in the activity of the drug trafficking. Definitely, to combat the drug abuse and trafficking, India has taken the various initiatives to regulate and prevent the drug trafficking in the various ways. In 1985, India introduced the national policy on the narcotic drugs and the psychotropic substances to regulate and control the drug trafficking in India. In 1986, India established a Narcotic Control Bureau is a nodal agency to enforce the drug law in all over the country. The Ministry of the Home Affairs constituted 4-tier coordination mechanism amongst the nationwide stakeholders from grassroots level to the apex level to effectively combating the drug abuse. For 2018 to 2025, the MOSE launched the National Action Plan for the Drug Demand Reduction to reduce the adverse impact of the drugs by implementing the various strategy, which includes the awareness programs and the interactions with the parents, young generation, and also the organizes the various workshops, seminars in the colleges, universities, and the schools, and it provides the treatment facility and capacity building service provider. On the occasion of the Independence Day on 15th August 2020, India launched the Nasha Mukti Bharat Abhiyan, that is the drugs free India campaign in 272 districts in 32 states and the union territories, and which assisted under the NAPDDR scheme in association with the all voluntary organizations. India also integrated the rehabilitation centers for the drug addict and to provide the assistance to them for the rehabilitation. India signed the various international conventions and treaties and bilateral agreement to regulate the drug trafficking, like UN Single Convention on the Narcotic Drugs 1961, the Convention on the Psychotropic Substances 1971, the Convention on the Illicit Traffic in the Narcotic Drug and the Psychotropic Substances 1988, and the UN Convention Against the Transnational Organized Crime 2000. India also signed the various mutual legal assistance treaties with the other countries for the purpose of investigation, prosecution and extradition of the drug traffickers. It will provide the legal framework for the sharing the information and evidence between the signatory countries. India is a member of the various international organizations like United Nations Office on the Drug and the Crime, International Narcotic Control Bureau, and these organizations work in the coordination to prevent the drug trafficking at the international level, and it also cooperates the other countries to joint operations and sharing the intelligence to prevent the drug trafficking. In India, drug abuse and the trafficking are controlled by the Narcotic Drug and Psychotropic Substances Act 1985, and according to the provisions of this act, cultivation, production, transportation, import and export of the narcotic drugs and psychotropic substances are prohibited, but except with the governmental permission and the medicinal and scientific purpose, these drugs are allowed. So, in spite all these initiatives, there are the many issues and the challenges to combat the drug trafficking from the grassroots level. The drugs traffickers are more technologically and advanced nowadays, and they use the internet-based technology for supply of the drugs also, and use the drones for the supply of the drugs across the border. Due to the growth of the industrialization and the unemployment and the youth culture, leads the crime of the drug trafficking in all over the world. Drug trafficking is recognized as one of the organized crime which helps the financially support to the terrorist group to conduct the terrorist activities and supply of the drugs in various ways to facilitate the illegal activities worldwide. Despite all this, there are the political issues, instability of the in politics. There is a lack of the coordination to handle this issue and to tackle these issues effectively. There is a lack of the awareness among the people about the drug abuse and preventing measures used for it. In most of the countries, it is closely related with the violent crimes which affect the public safety and the social culture. It also relates to the other forms of the offenses which indulging the terrorism, corruption, and the money laundering. There is an increase in the production of the new synthetic drugs regularly, so the enforcement agencies also the public must be aware about the new trends of the production of these illicit drugs. To combat this menace of the drug trafficking, the following measures and recommendation I'm going to suggest here. It is necessary for the government to enhance and improve the border security by strengthening the security force and increase the surveillance by the adapting advanced technology and the AI. There is a need to strengthening the law enforcement agency which are involved in the drug controlling and preventing drug trafficking by giving them proper training and the resources. The government has to take the initiative to enhance the international cooperation with the other countries to tackle the issues relating to the drug trafficking. There is need to give the more attention by the government to the issues relating to the unemployment, poverty, and the education and other socio-economic factors, to provide public awareness among the public regarding dangerous drugs abuse and prevent the drug trafficking network, which will help to reduce the drug demand of the drugs. And the government take initiatives to make the more stringent laws and regulation to control the prevent drug trafficking. I would like to conclude my topic that drug trafficking now becomes a new threat to the national and the international security. It is a transnational crime, hence it is need to the global response to combat the menace of the drug trafficking. Thank you so much.
I think very important issues dealt with by. I thought you will give some idea about this money laundering.
Yes.
In a wider sense, because it has become one of the very, very
Yes.
difficult areas in Indian courts. People who are accused of money laundering, of course, it's legislation which is not an independent legislation. It is the schedule offences that are
Yes.
given in the Act. Now, getting a bail has been a big challenge, and also that now the Supreme Court is slightly becoming liberal, not liberal, but it is slightly deviating from the very hard stand that it has taken. And the second aspect that I think you could have taken up is about the confiscation of the properties.
Yes.
Because that is where you give death knell to these people. If you have the power to acquire the properties, state acquires the properties, and therefore economically you bring a death to these people. I think this is one of the measures which is thought to be one of the
Yes.
aspects that could have been taken up. Yes, ignorance about the horrible effects of the misuse of the drugs is not yet percolating down to the society. And also there is a border security issues which are very, very important to be dealt with, and strengthening of enforcement agencies. And a big challenge is the corruption.
Yes, definitely.
And then, of course, need for the cooperation at the transnational level because of the people operating outside India, and then activities are done in India and neighboring countries. How do we deal with these kinds of situations is itself a
These are
very big
the
challenge.
major issues.
Very big challenge. Thank you very much for your wonderful presentation.
Thank you, sir.
I hope you will try to cover some more areas. I think the challenge is that we are about the that Money Laundering Act itself was under challenge before the Supreme Court. Yeah. And we have now Vasudha Bali. She is a researcher at the Premier Research Institute of India, and I am sure she is going to give a very good food for thought. And she is dealing with something very new topic, I think, human trafficking in sports and technology.
Yes.
Is it?
Yes, sir.
Opportunities and challenges. Yes.
So
Is
good
it a
mo-
part of your PhD topic?
So my topic is PhD topic is sports law challenges for a gender.
Okay.
So it is just an. So good morning, everyone. My topic is human trafficking in sports and technology, opportunities and challenges. So, trafficking of human beings is one of the most lucrative organized crime, as we have heard from our other presenters. I will be touching upon how sports is connected to this problem. So, I'll be touching three aspects. One is sex trafficking, labor trafficking, and the lesser known athlete trafficking in the world of trafficking. So the purpose of paper is to explore or examine the complexities of human trafficking within the sports and provide how technology-based measures and the other measures which can be taken to address this. So, first, the term human trafficking and human smuggling is often used interchangeably. So, I would like to highlight, though both are very interlinked, and but the meaning has been quite different. The human trafficking, as defined in Palmyra Protocol, it involves the act of recruitment, transportation, and harboring through force, coercion, and deception or exploit for the purpose of sexual exploitation or forced labor. So the consent somehow become irrelevant here. However, human smuggling, defined in the Protocol of the against smuggling of migrants, it involves the illegal entry of the individual for the financial gains. So, however, it can occur with or without the consent. So, the distinction lies in the first is focusing on the aspects of the exploitation, whereas the later is focusing on the how the entry is being made. Although there is quite overlapping, because the people who are involved in trafficking and smuggling are often same. Those who have a knowledge how to make the illegal entries into the different destination points. Now, if we talk about the sex trafficking in sports, so we all know that this problem of sex trafficking we are facing, but how sex trafficking is related to sports? Now, the mega sports events when are often organized, like the Olympics or the World Cups, then it opens the huge influx of the people. So, large number of people are coming, and it becomes sometimes very difficult to identify who are coming to proper legal channels and how the people are being trafficked or coming through illegally points. So these events create somehow a hotspots for the trafficking for the sex trafficking of the women and children especially. So I have covered few incidences where it has been identified that there have been some issue of sex trafficking even in the recent Paris Olympics, although the most time the governments have not identified it as a sort of a problem, which is in itself an issue, because unless until you identify it as a problem, you cannot address it. So people are focused on the event can brought a glory to the country who is organizing this event, and however the problems which are associated with it are not being are often hidden. So that's why we need to look into this problem, that how we can sort it. So mostly in these cases, civil societies are coming forward in the respective countries where the events have been organized and they've been been handled that the issue should be handled at the initial stage or the preventive stage. So the legal framework we all have heard from ma'am, there is extensive legal framework. However, it is a journal framework. The sports have not been addressed. The issue of sports have not been addressed in such the frameworks. Now, if we talk about the labor trafficking in sports industry, now again, when we are organizing events, we need a quick creation of the the infrastructure that we need. So there is the influx of the migrant laborers, there is a trafficking of labor, and there is a huge problem of a forced labor. Now, there are few incidents, but the most problematic was seen in the recent Qatar World Cup in 2022. The reason being the legislations of the country itself. So the host country has a system of kafala system where the sponsor is attached with the person who is coming for the labor. Now, until the sponsor is paying for all your amount, and unless until you pay your whole amount to the sponsor, you are attached with it. So they start exploiting the person who is coming for the labor over there. So this other than that, the American countries the America also, there were a lot of companies which were providing services in the Qatar, and they was seen that they took the laborers to the Qatar. However, they could not enforce the proper laws that are required to have a labor over there. So a lot of people died and are still fighting for the compensation. The FIFA faced the huge heat because of that. There was a official complaint made against them in the before the OECD guidelines. However, since these were the merely guidelines, so the only mediation part happened, due to which FIFA intervened and asked Qatar to have some proper regulations to look into that the labor is being treated properly. Besides that, still there is a case pending in the US where the Filipino workers who were working for the American industry, labor industry, which were taken to the Qatar, they have filed a case against that firm under their own trafficking act that they have violated that track. So the labor trafficking is another problem which has been faced due to the, again, same reason. We are so much involved in the glory that comes with the event. We are just hiding the problem which comes with that, and we are not properly addressing it. The third and the most important is the athlete trafficking that we are quite ignorant about, I would say. I also came across when I was studying about the sports law that how athletes itself are being trafficked. So leave about for the sex or the labor trafficking, the huge amount of athletes who are interested in football especially and the baseball in America are being trafficked from the European countries. The footballers are coming, and Cubans who have a lot of similarity or the interest in a baseball, they are being trafficked or some smuggled into the US. So they are facing the huge problem in this respect. So there is no, I would say, the recognition of this problem, although the European countries and the FIFA itself is looking into it, but it's still a very unknown problem presently, especially maybe the European world or the US knows about the Cuban problem, but other world are still unknown about that. Even India can face, although India presently is maybe not, because the football and the other games are not that much interested, but as the football is increasing in India and the other South Asian countries, India may also face a lot of problem related to athlete trafficking. So we need to look into this problem, that how it is connected, how it can be addressed. In this respect, I would say, again, the countries are very much important. See, the Obama administration tried to improve this problem of Cuban trafficking of players by allowing them, because they have their sort of internal rivalry, because of which they asked that when you come to the US, you should have a proper nationality of other country, otherwise they don't allow. Now, but later on when the Trump administration came, they cancelled that agreement between. The purpose was only Obama administration was to stop this trafficking of athletes itself. However, because the other administration cancelled it, it could not happen. So again, the circle is going on. So I'll just specifically have looked into the FIFA, how they are addressing it. So the problem started with the Bosman case. It's a very famous case. It came before the European Court of Justice, which allowed the transfer of the player. So prior to Bosman, the FIFA regulations have a very strict guidelines about how to transfer the player from one club to another or different country. But Bosman case, International Court of Justice said that this is against the movement, right to movement. You cannot put these regulations. So the transfer opened. So now transfer opened, that because of that there was a huge problem that how to address the prices and everything, and that led to the increase in the coming of the African players, especially the Western African countries, where the traffickers or the smugglers took the opportunity and they identified that since the African players have a lot of interest in football and everything, and they meet the requirements, they start asking those, especially the children, that they come and start playing for the European clubs. And that created a problem. Now FIFA tried to address this. They made changes in their transfer of players agreement. They made a change in Article 19 that unless until the under 18 players will not be allowed to transfer unless until there are 3 exceptions, that the parent itself is coming to the country, or it is within the European Union, or it is within the 100 kilometers of the borders of European countries. You cannot make a transfer. Also, there a mechanism, a body has been established where because of only the permission of that body you can transfer, or they keep a regulation. They issue passports to the players to regulate and see that where transfer is happening. Besides that, they also had another measures, like I said, their online transferring matching system, club licensing system, training compensations already made. These all mechanisms is provided to the smaller clubs that they should have some incentive they are providing, and they do not get involved in the trafficking of. So similarly is Article 19 base, which is for the private football academies, that require that you mandatory report about the minors who are coming to the for the football. How the issue is how to target the unlicensed football clubs. So there are a few unlicensed also, and for that there is a issue. Now for a part of a technology, the technology is being used both by the traffickers also, with the change how the technology is developing, and same way it can be used for prevention also. There are a lot of tools presently. We have AI technology, we have blockchains, victim providing, so there are forensic technologies which can be used. However, we have to use these technologies with some ethical consideration that we should not violate the privacy of that person. So in conclusion, I would suggest that we need an international cooperation. We need to identify this problem. The Palmero Protocol does not look at this problem at all. For the countries, it is not even a trafficking, but the person is coming with the consent, and they are just looking for an opportunity. However, when they are left in that country without any support, it creates a problem for those children and the athletes who are coming, and the other aspects also. So we need all these other initiatives on the part of the international federations also, like FIFA, IOC. All these also need to come, and international cooperation and the corporate also need to be responsible when they are addressing this. Thank you.
I think it's a new area which has come to light. I hope you've done a lot of, there's an empirical study about what you have presented today.
Sir, yes, sir. Sir, I have tried to identify as much incidences that have been identified throughout the internet or the legal proper research papers. So
this problem must be there, but then the magnitude of the problem,
yes, sir.
Is it growing with the more and more interest of the people in sports across the borders?
Yes, sir.
And that aspect is a very important aspect. I think good area, I think a new area, emerging area of study. Thank you very much for your presentation.
Thank you, sir.
Now we have the last presentation. We're much ahead of the time because 2 of the speakers have not come, and even the co-chairperson has not come. So we have Mr. Arjun Gain and Mr. Surya Kanan, who are from Amity Law School, Noida. They are going to make a joint, no, okay, it's a separate presentation.
Yes, sir. We go to other, so he will present.
Okay, all right. What is the topic of his?
Unsheathing.
Unsheathing the double-edged sword. A critical study of the drug trafficking landscape across South Asia with special focus on digital forensics. You're also presenting the same topic?
Yes, sir. So I am the co-author, so he is present.
You are not presenting. That's what I was asking you. He is presenting on behalf of both of them, but questions will be answered by both of them. All right.
Good morning to all.
So you're studying with respect to South Asia,
Yes, sir.
Yes.
right? Okay.
Good morning to all, fellow panelists and delegates. I, Arjun Gend, along with my co-author Surya Kannan, will be presenting a paper titled Unsheathing of Double-Edged Sword, Study of the Online Drug Trafficking Landscape Across South Asia with a focus on digital forensics.
You're free to take as much time as you want.
Thank you, sir. Our paper primarily addresses the challenges of online drug trafficking in South Asia, wherein we try to study the aspects of traditional crime integrating with technology. And further, we also try to explore the various methodologies which can address the same by equipping ourselves with digital forensics. To start with, much has been elaborated by the fellow panelists, but I would just add on. We have a historical context in terms of cultivation of drugs. Opium was cultivated. Sorry with the slide bit. Opium was cultivated and for medicinal purposes, and it has been documented in historical text. The fact being that the cultivation was always a contentious issue, which has been dealt even during the Mughal era, where the crown had taken over the entire cultivation rights, and then we have seen wars being fought for control of cultivation. And subsequently, post-independence, we have seen that legislations have been brought into force in order to control the cultivation bit. But there has been also an issue which we are trying to address, and which the legislations have also tried to address, is the scientific advancement which has moved opium from not only in its primitive format but into other opioids which can be used for recreational purposes. In this endeavor, we further moved ahead to uncover the role of internet in drug trafficking. Now, in drug trafficking in its primitive format was facilitating the transactions, but it has come to a new stage with the intervention of internet. Internet has upscaled the business of manufacturing, trade, supply, which has led to an unprecedented growth of consumption of drugs, sale of drugs, and which has been documented by the United Nations Office of Drugs and Crime in the World Drug Report 2023, wherein it has talked about 296 million people actually being consumers of drugs. Once we look at this aspect, we are also seeing how the government has tried through guidelines being provided by the International Narcotic Control Bureau in various states to actually control the abuse of internet space by regulating the marketplaces. Internet spaces, we don't only reduce it to e-commerce platforms, but also social networking sites and other various online portals which are mediums of communication. The proliferation of internet has been such that the traditional drug trafficking and the cyber crime in the present time involved with it has blurred the line with respect to the process in terms of investigation and the legal framework which deals with it. While moving ahead, we had actually seen how the online cyber crimes like phishing, cloning, and other aspects of cybercrime have been defined under legislation, there has been an issue wherein we have been unable to define online drug trafficking. So we have just tried to highlight how online drug trafficking shall include or is these propositions wherein we say online drug trafficking is not only limited to the sale of the drug, it is also in terms of manufacturing, production, and also distribution, which has been prohibited by the legislations of respective countries. When we move to cyber-enabled crimes, we are cyber crimes, it's basically user of internet. But in the present case, our paper, we are trying to understand how the traditional crime has merged itself with or integrated itself with the technology and has actually created a sphere where we have a hybrid crime, which we have tried to address but not been able to address completely at the global forum. Now, with respect to that, we actually would try to give a depiction of how it happens. We have traffickers who have access to online marketplaces, which are both index platforms and the unindexed platforms. Index platforms are like platforms which from where we can retrieve data, and unindexed platforms would be data like would be places like deep web, dark web, wherein we have a supply mechanism in place for drugs. Now, when we look at this representation, we see how the traffickers actually come to the online marketplaces, facilitate the connect between the producers and the purchasers, and further we see the user of digital payment mechanisms to actually facilitate the payments also. So if we actually break it down, we only see a representation wherein we see that the person who's actually the perpetrator of the crime is actually sitting somewhere calmly and conducting the crime in a way wherein he has mules deployed who would ensure delivery of the drugs or use postal or courier services for delivery of the drugs, and then money mules actually ensuring the delivery of the payments, who in the investigation process would actually only bring the investigative agencies to a dead end, not actually making the real perpetrator come for the conviction. With moving ahead, if we see the legislative intent, we have actually tried to see it in terms of the Indian context as well as a few of the South Asian countries. We see that though we have distinct legislations in terms of the IT law being governed by a different legislation and narcotics being dealt with a different legislation, we see a time gap between the enactments in the various countries in South Asia, and also we also see how the issue which is in terms of
Sri Lanka is 1084. There must be some mistake. It must be 1984.
It's 1984. Apologies for that, Chairperson. No, the issue which we were dealing or we were trying to address was the hybrid crime, which none of the legislations have actually tried to address in their codification, where we also get to see that due to the inability of the legislation and the prosecution to actually bring this to light, we see many criminals actually escape the prosecution.
What is the Pakistan and Bangladesh? Do they have a different law on the subject in the sense? Because what they have been doing is they've been copying Indian law substantially. Is there a difference between the legislation in the three countries, or the same legal framework remains the same?
It's primarily the same legal framework, but not addressing the issue of a hybrid crime where we deal with drug trafficking and technology together. Moving on,
does India address it?
No, as of now, we don't address it, but we appreciate digital evidences as a mechanism for prosecution. Moving ahead, I would actually, what we had in our research tried to address was the intervention of digital forensics as a mechanism to connect the dots between the crime and building a case where substantial evidence is present for the prosecution or the agencies to prosecute the accused. In this, we actually, in our research paper, we have tried to address the different types of digital forensics, starting from network forensics, wherein we have seen data collection takes place from the device, emanating from a device involved in a crime, and where careful analysis is done with respect to the focus of the planned intent, why the device was used, or messaging which has been used, which has been further classified into different categories, that is catch it as you can system, which is a form of a network forensics, and stop, look and listen system. In these two mechanisms, we see how the data packet movement actually takes place between two ICT devices or various correspondence which takes place between people having an ICT device with other ICT device holders. Further, we have also seen where in the realm of dark web and deep web being there, we are actually dealing with software forensics, which is coming into place because of the issue where disk encryption is something which has come into foray. Now, with disk for the disk encryption to be there, it avoids detection for the ultimate user and for the investigative agencies to point out who the actual user was. So we have actually developed a system where in software forensics we are able to get onto that. With respect to the other forensics, wherein we have mobile forensics and email forensics, which have actually analyzed data emanating from a mobile or from a source to another source, and also has actually had seen how the advancement of technology in respect of mobile phones, how it has been seen earlier. We had seen a system where pagers and mobile phones were used to evade detection, and now it has come to a foray wherein we see the movement has come to facilitate easy transactions in terms of the smartphones coming in place, which has made it convenient. As in, we get access to applications, we get access to various internet websites which actually help us. Honorable Chairperson, sir, can I get an extension?
Well,
Can I get an extension?
yeah.
Would be good. Yes. With this, we had actually tried to build up our cases, our research paper around how forensics is very crucial, and in today's time, how digital forensics, though it is prevalent, how an upgradation of it in terms of investigative tool shall actually help the entire ecosystem to deal with the issue of drug menace. The last bit of the fintech forensics, because we have seen a digitalization era wherein we have seen payment mechanisms being done through digital portals or through cryptocurrencies. There has been a need, and actually it has been also been documented in the in one of the cases in the Pulwama attack, wherein digital forensics had actually led to the inflow of information with respect to who all people the terrorists were connected to. Now, with that kind of forensics, wherein we have seen terrorist activities being subjected to digital forensics at that stage, our intent is that in terms of drugs or drug-related crimes, we also move beyond the traditional way of investigation and come to a platform where digital forensics are incorporated in terms of investigative tools. Moving ahead, if we actually see why we wanted to address this issue of the hybrid crime was very simple. The user of internet has been absolutely increasing. Now, with that in place, we have also seen how the internet has not only facilitated the transaction process in terms of procurement and payment of the drugs being procured, there has been a user of another crucial infrastructure, which is the courier and parcel movements which have take place both domestically and at the international level. We have seen how custom in Indian cases where customs officers have tried to intercept such parcels and actually get hold onto the actual accused, which too much of the efforts of the investigative agencies actually is lost in vain, because the parcels usually are named or titled in names which don't exist or addresses which are non-existent. The way forward which we envisage after our analysis of the various aspects of the hybrid crime in terms of the South Asian region, we had actually come up with an understanding that the South Asian region is an area which has actually seen drug trafficking and drug cultivation as a primary issue, and addressing it together would be a step which shall help the global cause. Now, when we intended to suggest with this paper was that we have a digital forensics in terms of the unsheathing of the virtual reality of the online drug traffickers was our first intent. The second intent was how drug trafficking and cybercrime is undeniably multifaceted. Okay, and
that says the end of the.
Yes.
Or do we give him some more time?
Oh, it's just a moment. I was about to finish. And with respect to the international cooperation, since if we look at the hybrid crime which we are trying to address with the advent of internet and drugs actually being circulated through the internet medium, we suggested a cooperation among the countries to come together and help each other in terms of the technological support system and the investigative support system. Last but not the least, we expected that a public and private partnership between technology companies come in front and help the investigative agencies to build measures to prevent the user of internet as a sphere for drug transactions, as though internet is regulated by territorial laws, but at a global forum it remains unregulated. With that, I conclude. Thank you.
I think a good presentation on some new emerging things in drug trafficking. I think what you said was hybrid crimes, right?
Yes, sir.
I also say hybrid investigation.
Yes.
Technology, if it can be a perpetrator of committing a crime,
yes,
it can also be used, harnessed,
yes,
for detecting of the crime. Like you gave the Pulwama example.
Yes.
We could understand from the investigation that was conducted as to where from does the information emanate,
yes,
and who is the controlling authority,
yes,
in the hierarchy of the offenders,
yes,
principal offenders.
Yes, sir.
So I thought you could not only say about hybrid crimes, but also hybrid response of the technology in hybrid investigation. I think that's something which you said in the end that it needs cooperation,
yes,
across the countries.
Yes.
And therefore that cooperation is very, very vital. I think that has been highlighted even in the UN Convention also.
Yes.
Because without the transnational cooperation, I think we'll not be able to achieve any of the goals that we have set for us in the international convention. So I think this is a very important element that you have added to the that people do not resort to drug trafficking only through the traditional methods, but they have resorted to now use of the technology.
Yes.
And how this technology is working in the matter of not only procuring, producing, manufacturing, and distributing, and also money laundering.
Yes.
That's an area which I think is a good research done by you young people. Both of you have done a good job.
Thank you.
I think with that we come to the end of the presentation, but then there are going to be question session. I think we have one of the speakers, the first speaker who was here. I think he must be around. Mr. Anil must be around. Is he?
Yes,
Any questions
I am
you
still
want to? Anyone wants to put a question to him about his topic about illegal immigration and use of crimmigration? That's a very important. Yeah, this is an announcement. Yes.
Before the question and answer session, now I request Professor Anupam Jha, Treasurer ISIL, to felicitate our chairperson.
Oh my God, he's here. Thank you very much, Professor Jha. Thank you. God bless you. Thanks. He's been a colleague at Delhi University. He is now our professor in charge in the Law Center too. Thank you very much, Professor Jha. Yes, any questions on what was the presentation of Mr. Dr. Anil? Anybody? Even from the participants, speakers, if there's a question? Only I would like that there are some friends who have joined late. Could you sum up your recommendations for their benefit? Can you hear me, Dr. Anil?
No, I cannot hear the.
I said we have some. Can you hear me?
I can hear you right now, yes.
There's some of our very learned participants who have joined subsequent to your presentation. I would certainly like you to sum up your presentation with your recommendations as to what are the recommendations you suggest should be taken up to deal with the issue of illegal migration.
Yes, I will repeat them. I think regarding to the illegal migration towards India, I have suggested to amend at least some elements in the Indian legislation, such as the introduction of the term or the legal term of illegal migrant, the obligations for illegal migrant, obligation to return, and more possibilities for the state in order to facilitate the return. Secondly, I have suggested to straighten the borders with more control from the border police. Thirdly, I have suggested that regarding to security and illegal stay of migrants in India, more investment should be made regarding to the police, more investment in the immigration authorities, and also, importantly, the Indian judiciary. Fourthly, I have suggested to make bilateral agreements between India and third countries, readmission of nationals staying illegally, and after necessary verification, the obligation to send them back, in which, of course, India can get assistance and advisory from international organizations such as the International Organization for Migration or the United Nations High Commissioner for Refugees.
Should we take it that your recommendations are that the best thing in the situations is that these people who are illegal migrants, they should go back to their
Yes.
national countries, and criminal law is not a solution to deal with the problem. Am I right?
That's right.
Like
yes.
suppose, because if you punish a person for being an illegal migrant, what will happen is he will continue to be in India only, and
Yes.
then the resources that we spend upon the person,
Yes, and it's
over the
costing
period of
the
time,
Indian state more costs.
yes.
And
So
I
therefore, the
think
best
therefore
thing is that a person
priority.
from the original state must go back to his own country, and that is where it should be facilitated through bilateral agreements between the nations also, and also the government's policy should be to ensure that as many illegal migrants are sent back to their own states of origin. Am I right? Is that
That's
your
right,
recommendation?
yes.
Thank you very much for your wonderful presentation, and thank you for being part of us all along and listening to our young academics and the researchers who are making contributions in the development of the law at the international level. Thank you very much, sir. Any questions to the other participants? Yes, please. You have a question? Two. Yeah. You can come here also. You will come to the dais. Okay.
Sir, can you hear me? Prahlad sir, can you hear
Yes.
me?
Yeah, we can hear. Acha. Oh, Mr. Anil, there is a question.
Okay.
Dr. Anil, there's a question, two questions, he says. Yes.
Sir, the suggestion you gave was like sending back those illegal migrants to their country of origin.
He did not say sending back, it is return. of those
returning by them. But there is a question of like many times those who are illegal immigrants, they are stateless people. So how can we find the origin, like their country of origin, and what could be done with those illegal immigrants who are stateless people? How to tackle such situation?
Shall I answer the question?
Yes. Yeah, you have a question? Yeah. Just a second. First, let his question be answered. Yes. Yes.
Yes, I think, well, people will say, of course, that they are stateless, but I think that you can always have a close look on what the identity is and what the nationality is. And for that, you should verify the nationality by presenting that person to a consulate or embassy in order to get a verification that the person is coming from another country. So I think in most of the situations, there is a clear indication where somebody is coming from. So that's first of all, I would say, a process in which you have to verify the identity and the nationality. So I think in most of the cases, the conclusion will be that the person is not stateless. So it's a verification procedure which you have to do with the country of origin.
That's right. Any question? Any more question?
Sir, I want to continue the. Sir, the problem will be like when the country like whom want to send back the to the country of origin. What if the country of origin saying that they are not our citizens, so we can't take them back? Like
he says that for that you should have a bilateral. Agreements between the nations,
Yeah, this could happen in an international cooperation.
And also, if that dispute arises, there must be a forum to settle the dispute.
Yes, but the problem will be like with the stateless people. Often these countries, none of the countries recognize they are their citizen. So the problem with the stateless people is that even though we are able to trace their ethnicity, they will not fall under any of state because no state want them. They are literally people who don't have any state, or no state want these people. So how can we deal? Like my question is like, can we have another mechanism or when we define the like sir mentioned, we have to include the definition of illegal migrants. So when we define this illegal migrants, should we make an exclusion that stateless people will not come under this illegal migrants under the definition?
I think, to be clear, it doesn't matter if they are stateless or not. If you're staying illegally, you should be qualified as illegal staying person. The problem is that, of course, and it's not only seen in the Indian context, we can see it also in the American or European context, that when you want to let people return back to their country of origin, that some countries of origins are not taking back their own citizens or their own nationals for several reasons. So therefore, you're sometimes stuck with these people on your territory. It doesn't mean that they will get then rights on your territory, because you will still qualify them as illegal, which will also give them the obligation still to return to another country. So sometimes that will be a complex situation, but therefore I have suggested to have bilateral agreements. But if that's not working in specific cases, the people, in the end can be coming in a situation which they cannot return, whatever the reasons are, but still they're staying illegally on your territory and they have the legal obligations to leave your territory. So it's an obligation you're putting on the person.
Correct. Okay. Yes, ma'am, you had a question.
Yeah, I had a question that is related to illegal migration. Now we have the issue of the Sri Lankan refugees in Tamil Nadu. So don't you think India has a duty?
It's the same problem like in Bangladesh, people in India or Sri Lankan people in India. I think answer is the same.
So I think we need a duty under public international law to grant them citizenship, because they are persecuted, right, on humanitarian grounds. Because when we go to America or Australia, Tamil people are granted citizenship over there quite easily. So why not in India? And why don't we integrate them into?
We are already a lot of population in this country.
And I can also add on this aspect, it's the Indian sovereignty to decide whether or not a person can be granted Indian nationality. So if you fulfill the conditions of the Indian legislation, it can be done, and otherwise it's the discretion, full discretion. Yeah. It's a International Court of Justice judgment in the case of Notenboom, 1955 already, in which it's stated that every state has its own discretion in order, to give the nationality. So that's Indians' choice.
He is talking about the situation where India is not prepared to give that nationality. So what is the solution? Solution is that he must return back to his place of his origin. Am I right, sir?
Yes, that's right.
Good. Thank you very much. It's Professor, you have some question? No.
It's been a wonderful session.
Thank you very much. Thank you for being a part of this wonderful deliberations today. We have benefited immensely from your presentation. Thank you.
Thank you very much.
Thank you. Yes, any questions to the other speakers? None? Did they not say something new? Was it the same music that was sung everywhere, elsewhere? But I think she sang some good music that side. She brought us to something like sports. Yeah, technology and sports, Yeah, you have a question. This man has now got a question. मैं तो 11 बजवाना चाहता हूँ. So that they don't say that we late before time, yeah.
My question is towards Vaishali ma'am. During her presentation, she was mentioning about the ILO convention on the prostitution, and when dealing with those things, she mentioned about the labor, the forced labor convention, and the other one was the against slavery convention. So when we see the prostitution, shall we consider it as a forced labor or a sexual slavery? Under which category we should categorize?
Yes, yes.
Thank you. Let me address one thing. In my presentation, ILO has two conventions, right? So it defines, it gives definition regarding trafficking. But what traffickings were more prone to have servitude, slaveries, etc., etc. But they have constrained that definition and what is to be included. Again, they have given there. Right. So according to me, that ILO convention only speaks about or talks about slavery and that type of things in that particular convention. Actually, every convention has its own aspects, right? So every
his question is, how do you connect these two conventions with the topic on which you made the presentation? Am I right?
Achha.
Is it that slavery can lead to prostitution?
Yes, of course.
If it is that position, then you have to say that why you are referring to these conventions is because ultimately abuse of the rights of the people can lead also to this kind of an exploitation. Yeah.
See, I have not go through the whole document, but I would feel that if you want to include it under the forced labor slavery, then you need to first recognize it as a labor. You will need to recognize the prostitution first. Then only you will able to apply that it is a slavery. You are forcing someone. Unless until it is not, then it is an entirely illegal activity and it is entirely trafficking or you are doing a crime. That's why the prostitutes are facing a problem because it's not a legalized. Has it been, then maybe we could have said that it's a forced labor. If you want to do, otherwise don't do. So I think that thing will depend upon, I guess, whether it is a legalized problem or not.
I think she was referring to was that there are different kinds of trafficking. One of them species is prostitution, and one can lead to the other. The correlationship between the two could take place.
Ma'am, correcting question, just follow-up question. So when we, ma'am was correctly pointing out that in many countries it is prostitution legal, but in other countries it is illegal. And there is this issue of force or trafficking of women for prostitution. It has been always since time immemorial. So do you think that there is a need to a new convention where the countries should cooperate to recognize the prostitution as a even though not as a legal labor or something, but as a separate, there is a need to address a convention, there is a need to address this issue, or should they include this in the existing treaties?
Yes. According to me, according to my opinion, it have some convention or anything that need to be addressed in only one platform. Even new emerging issues like technology, using of internet for trafficking purposes. Again, these things were not addressed at an international in the conventions related to trafficking. So, according to me, it requires.
Her question is, trafficking per se is wrong, illegal.
Yeah.
So when you say that some countries have legalized prostitution, I think they have taken safeguards also,
measures also.
Accepted it as a profession. So we are not talking about, we're talking about here in the matter of context of the trafficking for the purposes of prostitution.
Even they don't speak about consent, willingly they were or forcibly they were. So everything is just, it is not clear record. That's why.
Okay. Any other question?
I think
Yeah.
So, ma'am, is there is any conventions which has deal with the third generation, those who are involved in prostitution?
There's a
Third generation.
Transgender,
So,
it need to be addressed.
Can you-
Don't you think when they define sexual exploitation, they are not looking at the gender of a person? It can be a male, it can be a female, it can be of any gender. So I think at least Palmero defining it is defining it quite widely. Whoever is being trafficked for a purpose of sexual exploitation, whatever the gender, the convention can certainly, I think, can cover that aspect. I think so.
I think if you read Nalsa judgment of the Supreme Court, I think
Yes.
that answers this question. That's why now in some legislations we have third gender as being recognized as in pursuance of that judgment. Otherwise, it has a very wider connotation of a person. It does not include only male or female. It also includes transgender. That's what the Supreme Court said in that judgment. Well, I think it has been a wonderful having young people talk about various facets of the subject, that is human trafficking, which has different species. It could be trafficking of illegal immigrants, migrations, trafficking of women for prostitution. It could be trafficking in drugs. It could be trafficking in sports and technology. So I think many issues that have come up and the answers that have been given and the recommendations that have been made are worth pondering over. We must think about how best we are able to bring a way forward in the future. I think I would say that organized crime is a dynamic threat that requires constant vigilance and innovative strategies. It has evolved from United States. You could see the prohibition, bottle legging. It started. I think organized crime started with that bottle legging in the 1920s, and I think right to privacy emanated even from the cases that went a bottle legger trying to send information through a telephone booth, and police tried to intervene and intercept the conversation, and the court said he has a right of privacy, so you can't violate his right of privacy, right to communicate. I think those are very important developments that took place there during that period. So we have to deal with the complex issues that have arisen over the period of time in these areas. We need strong laws, of course, strong implementation, strong investigation, international cooperation, and public engagement is very important. And if we are able to take these strategies forward, we'll be able to push back these criminal enterprises. Organized crime is not the responsibility only of the law enforcement authority. It is a shared responsibility. All of us have to become parties, government, businessmen, civil society have to work together to dismantle these networks and create a safe and more just world. It is with these observations, I would say, that we conclude this session and hope to meet sometime future. Thank you very much. Thank you. Good, you must improve upon this article, publish it. That's a very, very good article. Yeah. Thank you.
Thank
you
you.
very much. I think
everyone. We have our session on international laws.
Can I give you an introduction?
Okay. The moderator wishes to take the floor first. So please, you have the floor.
Good morning, everyone. I welcome you to the 10th International Conference on International Law, Issues and Challenges, organized by Indian Society of International Law. This session is on international law's role in tackling climate change. Here we have Dr. Shikhar Ranjan sir and Dr. Anwar Sadat sir as our chairpersons today. Dr. Shikhar Ranjan sir is a director of Asian African Legal Consultative Organization. Prior to this, sir worked with Indian Society of International Law and Ernst Medical Council of India. Sir has immensely worked on environmental law. Dr. Anwar Sadat sir is a senior assistant professor at Indian Society of International Law. Now I request Shikhar Ranjan sir to give the keynote address.
Much for your kind words of introduction. Let's leave that part of the address at the end of the session, where I would summarize all the views. We should be giving first of all the floor to our distinguished panelists, which we have here. So I would first of all call upon Dr. Sudhir Kochar from the Indian Council of Agriculture Research to share his views on genetic resource jurisprudence and mainstreaming lawful conduct for sustainable development amidst calamity, conflict, and climate change threats. And we are also honored to have amongst us one of the ace parliamentarian of this country, our former president, Mr. Nachiappan. Sir, we are very grateful for your presence. It encourages and motivates us. Thank you.
A legal person, as you have already seen my credentials, Indian Council of Agriculture Research. So you can feel free because I don't have any acumen to that regard. But if I say jurisprudence is the spirit of law, I hope many of you will agree to me. So jurisprudence and sui generis systems, these may be two, you can say, distant hopes or hopes at the horizon in law that would try to bring the things back to the lawful conduct. And if that may be so, then even though my topic is not precisely on climate change, and it's just a string of that, it is linked to it, I will just proceed. So some of the target keywords to spell out and to weave in my lecture I have given. Well, I have got, unlike other speakers, many slides, many things, but I will not be speaking from the slides. I deem it to be presented, and of course, any of you who is interested, either they can download from my LinkedIn page, or they can request to the organizer and get a presentation, and we can interact on that if you wish so later on. And if you see the standing law around plant genetic resources, utilization and benefit sharing, so it is the trade related aspects, it is the conservation and access and benefit sharing aspects, it is the multilateral system of exchange and benefit sharing. Then it is about the advancement of technology leading up to the digital sequence information under the COP decision. And it is about the biodiversity beyond national jurisdictions under the law of the sea, and also under the conventions and agreements, etc., under WHO. Post-COVID situation, whatever has been there. I'm not going to read the details, but what pinches me and would like to share primarily with you here is about the tragedy of changing PGR narrative. PGR is plant genetic resources. So between 1967 and 2023, from the legal domain, if we talk, it is something like connecting between the tragedy of commons and tragedy of anti-commons. So if you have plenty, you use it, don't bother about the benefit to the one who is the custodian or the owner of that. And if it is anti-common, you want to put it into the exclusive domain, and then many of them are not even able to use the technology for further progress of the technology, but to talk of its utilization. And then you have systems like friends and others. So this basically was the use of germplasm for the breeding of new varieties. And for breeding of new varieties, first international convention was UPOV, the Union for Protection of New Varieties of Plants, 1961. And prior to that, only one country law, that was the patenting on, you can say, plants. The Act 1930 of the US was there. But that was talking of resources. And the resources where the deemed utilization of benefit in terms of monetary benefits and non-monetary benefits was subsisting. So gradually it has been shifted. And why? You will understand yourself. So it's institutional governance. It came under the purview of the UNFAO mechanism. And they had first the Commission on Plant Genetic Resources in 1983, and there was a non-legally binding instrument, the International Undertaking on Plant Genetic Resources, that came and reigned there up to just prior to the declaration of CBD. So you can say just 8-9 years. And during that also there were at least 3 revised agreed interpretation for that. So the gist of the international undertaking was that the plant genetic resources are the common heritage of mankind, which should be made unrestrictedly available. It was earlier said freely, and then it was revised to interpret it, that freely doesn't mean free of charge. So unrestricted access was an obligation, of course, which was agreed upon. And then one agreed interpretation was that the intellectual property right on the new plant varieties bred from the utilization of these genetic resources will be the type of intellectual property right that is to be granted under the UPOV system. And that is where the developing divide was very, very pertinent and clear. So on one side, the breeders' rights were emphasized upon, on the other side, farmers' rights, and to which even the developed countries at that point in time didn't accept as farmers' rights, but the concept of farmers' rights. And this 1992, of course, this 1993 revised agreed interpretation 3 by 91 said that even though this is a common heritage of mankind, and unrestricted access is, you can say, deemed to be there, but then it is subject to the sovereign rights of the nations. Since it was a non-legally binding agreement, so this credit is given generally to CBD that for the first time the sovereign rights on the bioresources, these were declared by CBD, but earlier to that, it was already there under the FAO mechanism under non-legally binding agreement. So this Nairobi Final Act, which had that encompassed the text of CBD in it, had also an Article 4 in which there were 2 outstanding issues which CBD could not have resolved. And one was what will happen to the concept of the development of farmers' rights law. And then what will happen to the ex situ germplasm collections that have been collected so far, which was about 4.93 lakh in numbers in about 16 CG center gene banks internationally, and of course some other gene banks. So for that, these two things were kept pending, and rest of the thing was directly signed and stamped as CBD, which came into force 1 year later in December 1993. So then in the trade side, because of that Uruguay round developments, the Marrakesh Agreement that sealed the trade-related aspects of intellectual property rights, and then it is a package of, you can say, agreements in which sanitary and phytosanitary aspects, because of the movement, international movement, transboundary movement nature of the plant genetic resources, that was important, and then technical barriers to trade. So where the technology and other barriers, which were technical barriers, legally so also, were to be accounted for. So now these developments at the United Nations and the international NGOs pushing access and benefit sharing from the spirit of the CBD to the spirit of multilateral system, ABS, access and benefit sharing, and the digital sequence information. So that is the, you can say, tragedy of the narrative mainly. What is happening is that something that is holistic, genomic, full form. I mean, conventionally, genome is a full form of plant genetically built so. And phenotype is what is there, the expression in the field. So from that, the drift has been to the technology-driven extraction of information and digitalization of information and precise utilization of information from that, and then asking for the intellectual property rights or other things on that information. So the system has again ignored the farmers' rights, which were originally perceived under the non-legally binding agreement, which have been agreed upon and are a part of the International Treaty on Plant Genetic Resources, but would be denied indirectly by these means. So this is the tragedy that we are talking of, which as legal persons you can think of. So I will not read these slides, I will not express these slides, but the things are there. So what are those radical changes? What type of this physical material to the information material and other things? It is there in this slide. And then we come to the interpretation part, genetic resources, because law demands interpretation. So CBD has defined it, international treaty has defined it. The question is that why two definitions, plant genetic resources separately and genetic material separately? Because genetic material they need for the purpose of breeding, and that is why that has been given a separate definition. But genetic resources as a matter of resource, which ultimately on which trade like access and benefit sharing part is implied, has been given. Then of course the PGR as seen by the FAO Commission and the treaty, most of the things I have discussed in just one slide, but I have given the details so that as students of law, as scholars of law, as teachers of law, if you are interested, you can discuss further, but this is the summary. Then this is means reproductive or vegetative propagating material of the following categories of plants and all, means here the custodianship of farmers cannot be denied in any case, but gradually when you are moving to information, that doesn't work. So it was too early to see DSI here. That is what I have just marked here in red. And then I don't know what is it. For the first time, this mention of DNA sequences, which led to DSI, has come in the 1997 document at the fourth extraordinary session of the FAO Commission, which was renamed from Commission on Plant Genetic Resources to Commission on Genetic Resources for Food and Agriculture, once the process for revision, which took 7 long years, was set in 1993. So then mention of BBNJ agreement, if you see similarly, up to 2019 there was no mention of the plant genetic resources. One full section was there, and this article 12 was there in the draft, even the chairman's draft, but suddenly then it vanished. And the trick was that it is only information, and it is about the benefit sharing on information that we'll be talking of. Then this Springer Open, there is a publication, the European Union's deregulation of plants obtained from new genomic techniques, a critique and an alternative option. And what did it say is that just to give way to the next building of plants, or you can say amending of plants through the biotechnological techniques which do not have per se genetic engineering into it. So means like gene editing and all, there you will have some soft corners, you can relax that. Means the business of IPR should go on, the business of economics should go on, and whatever happens to the biology. Thank you very much. And I will be, and now basically why I dare to give this topic here is that KK Singh from DU Law Center 1, maybe he is not here presently. There was one genetic discrimination spreading concept that was developed by the Dolphin Consensus Statement, and in this statement there were some participants from about 60 countries, 20 jurisdictions and 60 participants, and they made an analysis looking into the familiarity criteria concept, means they are persons knowledgeable in the area, knowledgeable in the art, and they had built some concept. And this non-discriminatory policy statement, it is very, very important and keen for you to learn. So here they say the whole genome sequence, the genomic variants, genetic research info, means wherever there are some chances of benefit sharing in real sense with researchers or farmers, those things are taken to the backyard, and something of information which can be mined by the private enterprises, that has been brought into the forefront. And this is the type of development which you need to understand yourself. So why I had accepted this challenge to speak on jurisprudence in PGR is because I had heard about medical jurisprudence. Then there is jurisprudence related to Article 27(3)(b) itself. Sir, I will need just 2-3 minutes more. That they say that patents must be granted to the biological processes as well as the biological, essentially, it is only essentially biological processes which have been excluded from patenting. And in the biotechnological processes, bacterium is involved. In the non-biological processes, gene gun is involved. Means it was for genetic, pushing the genetic engineering basically, that this was there. So you see the things between the lines in these arguments, and then you can draw your own course of studies and all. Then jurisprudence related to UPOV system, there it is that you can interpret that IPR is nothing else but an offshoot of the civil law, just to get speedy recourse as far as the legal disputes are concerned. Otherwise, because here the culprit, he was brought to, you can say, innocence, proving innocence of himself, and not only that, taking money back from the police, or you can say state government, because the information was exchanged so badly by them with the complainant that the person had significantly lost his money in trying to prepare something which he could have utilized after the term of the protection of that particular property would have been over. And he had legitimately procured that material. So I am just finishing that, sir. So I will not go to the details, only this model will tell you. Now there are 4 different agencies. One is the agriculture related, one is the sea related, the other is the health related, and other is the biodiversity related. There are 4 windows for exchange of information, but 1 window for the purpose of access pooling of that information. And the second model, there are separate doors and all the 4 agencies can have differently. So these are the things which are being only discussed. This particular part I would have loved to discuss, but time is not there. Please read these last 4 slides thoroughly. This story of canola only I will discuss and just vanish.
Mr. Co-Chair, we have other
Sir, what happened in the after? Yes, 30 seconds. After Second World War, this canola has been developed by denying the legitimate occupancy of the rapeseed on board in the world over, because it was an excellent lubricant and there was a hefty production and it was supplied to the whole of the world. And then this canola word is Canadian oil low acid. And earlier this name was given Lear and they say low erucic acid rapeseed. But it didn't work because it was not so attractive. And this is what I'm saying. If the biology, if the binomial nomenclatures are being challenged, if the whole genomes are being challenged and it is given to only the information and then benefit sharing on that part, then law has certainly a lot of challenges ahead of you to work on this area. So reason the biodiversity, if you work on that, or if you work on UN Security and Sustainability Council, because you are talking of sustainable development, you don't have any Sustainability Council in the UN.
Thank you, Dr. Co-Chair.
Thank you, Dr.
Please, I request Anwar Salat to take the way forward.
So thank you, Dr. Sudhir Co-Chair, for covering a very broad canvas, and it's very challenging, very technicalities involved. But there are certain things which are common to all the presentations that are to be met. Common concern, climate change, benefit sharing. These are the issues that draw commonality between each other. So CBD is the rubric around which all your themes, presentations were made. So one of the components of CBD is the access and benefit sharing, and that the major hurdle is benefit sharing is to be made by whom? Private player. Private player is, as we all know, cannot be party to a treaty and they are away from the obligations. So there is a lot of concern, there is a lot of writings are there that there has to be shared responsibility. Is one area where shared responsibility for humanity, private player, state, they also bear some obligations. This is coming with respect to climate change as such, that they will have to, if they are saying common concern of mankind. So they have to share technology, they have to give finance to developing countries. Then we can save the boat in which we are all there, that the planet, or share the benefit sharing, share all the information, share all the technology for the sake of humanity. And we have already seen the COVID-19 thing. So at least we should keep in mind that frame has not been integrated into general international law so far. So we have to see this from this angle. So I thank Dr. Koja for making the thing so simple, lucid, and very clear. So now the next presenter is Dr. Momita Mandal from TERI School of Advanced Studies, Protection of the Global Climate for Present and Future Generations and Technology and Law. So Momita.
So good morning all. Today the topic I'm going to present, it is the protection of global climate for present and future generations and technology of law. But I will give special focus on use of the artificial intelligence in climate action. So my presentation, it includes one small introduction, climate technologies, special focus on artificial intelligence, AI in climate governance, gender, climate change and AI, existing international legal mechanism, different challenges and conclusion. So in this presentation, I'll just flag the issues because the topic is very contemporary and more research is needed. So we all know that at this present time, the entire world is facing a triple planetary crisis, that is climate change, pollution and biodiversity loss. And climate change is a threat to the existence of human beings and all other beings in this world. So climate technologies that can help us to get rid of this climate crisis, and artificial intelligence, it can be a mechanism that can also basically drive, or that can also help to low carbon emission or maybe to take climate actions. So basically we all know that if you look at the definition of climate change, it is stated in the United Nations Framework Convention on Climate Change 1992 Article 1. So if you look at the definition, it clearly states that climate change, it is happening because of the human activity and CO2 emission. Now we'll see that what are the different climate technologies. So there are so many technologies are there, but I have just highlighted few. Like we can see that here one drone that is used for disaster relief, then electric scooter that also helps to preserve the energies, disaster relief robot that is used for earthquake or some other disaster rescue operations. Then green hydrogen technology, that is also one of the important technology that is emerging in India also, that we can see. Now we'll see AI. Though so many technologies are there which are basically using for climate action, but AI is also one of them. So if you look at the AI or the definition of AI or meaning of AI, so basically we can quote this Professor John McCarthy's definition. He stated that AI is the science and engineering of making intelligence machines, and the main basis of AI is the data. And UN Secretary General Antonio Guterres, he also stated that an AI that is reliable and safe and that can supercharge climate action. So we'll see that how AI is used for climate action. Like first we can see that AI can predict weather and climate disasters, iceberg melting, it can basically highlight that issue or problem, then maps deforestation, it helps communities facing climate change, it helps to basically assess the vulnerabilities, it also helps in carbon neutrality. So there are so many other functions are there, but these are the one of the important functions that I have highlighted here. So from these pictures, we can understand that how AI is basically using to predict the weather, then iceberg melting, how community they are using through their mobile phones, the AI technology giving them prior information about the natural disasters. And here you can see the last one, that is the solar powered microcomputer monitor, which is basically monitoring deforestation by capturing the sounds of different trucks or some other illegal activities which are happening in the forest area. So these are the few examples which basically where the AI is used, AI technology is used for climate action. So now we'll see that how AI is used and how AI can basically contribute to climate governance. So it has seen that data is the main basis of AI, and through data that government or the stakeholders, they can get informations that where and which area it should basically give special focus and what type of policy, basically climate related policy, it should adopt. So there are several cases where the AI has been used and it is basically helping the government. So now we'll see the climate change, gender and AI. So it has seen and it is already proved that effect of climate change, it is not gender neutral. There are few groups of people are there, especially the women, children, disabled people, old people, they suffer most. Women especially, they suffer double victimization because of their gender as well as like all other human beings. So AI can basically collect the gender disaggregated data, and it helps the policy making, helps in policy making, and also the governments to take different actions that may give special focus on gender. Also, the AI powered chatbot that helps women take the first step to seeking information about what is happening relating to climate change, and to take different adaptation technology or adoption mechanism. So for one example is that one problem is that because of their already sexual and gender-based violence is there, gender discrimination is there within the society, but because of climate change it exacerbates. So what happened through this AI technology or this CIS boat that is actually used in Thailand, and where AI technology is basically used, and through that technology that women or the victims, they can basically get information that what should they basically do when they are suffering different forms of gender-based violence. So this particular technology has been used right now. So now we'll see the legal mechanism, what is there, how it is basically tackling the AI issues. So if we look at the UNFCCC, which is the main important law relating to climate change, so Article 4, it provides the development and transfer of technologies that reduce carbon emission. And the Kyoto Protocol, it also talks about the technology development and transfer. And if you look at the COP16, there also it basically established technology mechanism to support developing countries. Article 10, Clause 4 of the Paris Agreement, it talks about the technology framework. COP28, there also Decision 9, if you look at Decision 9, it also talking about the technology development and transfer of the technology mechanism. And in 2003, the technology mechanism launched its initiative and artificial intelligence for climate action to explore the role of AI for the climate solution. And if we summarize the entire legal mechanism, we can see though basically there is no such specific international law relating to AI, especially in connection with climate change, but through this transfer of technology or development of technology, it includes the AI mechanism also. And this Article 10 of Paris Agreement, it talks about technology framework. Technology framework, it also provides support to the governments to adopt regulatory framework that includes AI technology also that can be used for climate action. So if we just look at the present scenario, so we can see that AI knows no geographical boundaries, so the possibility of use and abuse of AI, it is robust, so there is need of one regulatory instrument, international regulatory instrument. In 2021, the Indian Niti Aayog issued a document on responsible AI for all. The UN General Assembly mandated the 2024 summit of the future and it basically given special focus on AI and use of AI, including climate action. Now, if we look at the challenges, so we can see that AI basically, the basis of AI is data, and data, to store the data, it needs more energy. So there is one side we are talking about preservation of energy, so it can basically cause us carbon emission. Then data may be biased data, so it may give wrong message to the policymakers. The lack of transparency, issue of IPR, intellectual property right, that is also one of the important challenge that is connected with this technology or AI. And inadequate representation, that whatever the data is gathering and that is interpreted, that may not be adequate or may not be suitable for the present scenario. And ethical use of data, especially the privacy issue, that how data can be used, what type of data can be used, and what regulation or what that threshold should be there. So that is one of these are the main important challenges that are basically right now present. And for that reason, my suggestion is that there should be use of science in policy making, need for a law relating to AI or technology mechanism specific law, and there should be interlinkage among the different existing laws like AI related law, climate change and environmental law, other related international laws like human rights laws. Then only this technology can be used properly for the climate action. Thank you.
Thank you very much, Dr. Mandal, for your lucid presentation and taking us through the role of technology in shaping responses to climate change. I request Mr. Anwar Sadat to say a few words on your presentation. You can please come.
Yeah, it's artificial intelligence can help in guiding climate action. There is no doubt about that. That sharing of information, sharing of knowledge, sharing of this is the technology that we should use to mitigate greenhouse gases, how to adapt to impacts of climate change. So these are data relating to extremes of weather, extremes of precipitation, extremes of drought, desertification, other policies, equipments. Yeah, in this area, that the artificial intelligence, of course, can help. But the point is that the real challenge is regarding climate change is that it affects our economic development. And economy is the main where entire debate, discussion, fight is there. If you want to prevent climate change, you have to shut down your greenhouse fossil fuel driven industry. Coal, all entire factory, coal mining operations, oil drilling operations, all those have to stop, and economy is, because we have to shift in all sectors. This is the Paris Agreement says that we have to shift in all sectors. I presented yesterday on the aspect of just transition, that when we are shifting, so workforce, how to adjust the workforce who are going to be unemployed, how to adjust them, who will pay them, who will give them employment. Okay, this is the main debate that is going. We need fund. Developing countries are consistently saying we need fund, we need technology, provide us. So everything cannot be given, but still your presentation definitely helps in that the pointed action, that the precise action, artificial intelligence can help, and it can be useful. It can be useful. How it can be useful? Because as regards technology, that the entire literature on climate change, if you find that it is on technology cooperation, it is not that you will be given hardware. It is not. If you read the language, technology, capacity, development, cooperation, there can be workshop on technology, but it does not mean that you will be given hardware. You can learn few things. You will learn few things. You will be given some money to organize a seminar on technology. But the transfer of hardware is the main. That is not there. On that point, there is full stop. So with this, I thank Momita to giving a new thing in the. I really liked it. Thank you very much.
Let's move on to the next speaker, Mr. Praveen Kumar. Please, you have the floor, sir. Mr. Praveen Kumar is with the B.S. Abdur Rahman Crescent Institute of Science and Technology, and he will be speaking on international environmental legal framework, the initial impetus to prevent ecocide against crimes. The floor is all yours.
So this is a typographical error. I am from Lovely Professional University.
Okay. So I stand corrected. Sir is from Lovely Professional University, Jalandhar.
Yes, sir. Exactly, sir.
Most welcome, sir. The floor is all yours.
A very warm good morning to all. Myself, Praveen Kumar. I am a researcher from Lovely Professional University, and I am covering green crimes within the precincts of the international environmental law. My topic is international environmental legal framework, the initial impetus to prevent ecocide against green crimes. Basically, my research paper covers three most important aspects and approaches. That's one of the criminal law, how to criminalize the act of the green crimes, and second is the criminology, and how to prosecute that criminals, and third is the conservative sciences, that is to protect the environment, how to protect the environment. What is the objective of my research paper? That is to find out the efficacy of the international law. We have almost 250 international treaties and various instruments. That is, we can find them ineffective still in the scenarios. If I see in current scenario, now I'm in Delhi since last 3 days, and I'm feeling that it's very hard to breathe in Delhi. All of you also facing the same problems here. So my research paper covers that the environment is often perceived as an existing outside of ourselves. This is the major factor of ecocide. We generally don't consider that the environment is a hull of our entire integral body. We conceive it at outside from our life. That is the major factor. That is the cause of the victimization of the environment. And another thing is that there is no exact definition of the environment. We cannot wrap the definition of the environment in one sentence. Although the Environmental Protection Act 1986 that defines that environment includes all the physical and biological surroundings of an organism along with the interactions. That is the most common to the combination of biotic and non-biotic elements. And if we give the definition of the criminology, green crimes, then we can say the definition of the United States Nation Crimes and Justice Research Institute. That is the most appropriate definitions. The illegal movement that comprise a wide range of unlawful activities such as illegal wildlife trade, illegal smuggling, ozone depleting substances, illicit trade of hazardous substances and waste, illegal unregulated unreported fishing, illegal logging with the aim of timber trade. What kind of green crimes we have in our universe? That is like illicit trading of wildlife. People, that is, we can say that the organized rackets, organized criminals, they used to commit the crime in one country and used to escape through the boundaries to another country. That is the main reason they cannot be caught. So illicit trading of wildlife and their protection is the major, we can say that a major event of green crimes. Another is the smuggling of those substances that causes depletion of ozone against the norms of the Vienna Convention 1987. Dumping of carrying illicit trade hazards, that is basically dumping of hazardous substances held in Europe, because that is enclosed with the boundary of the geographical boundaries with other countries. Illegal, unregulated and unreported fishing, that basically happens in the Norway fishing harbors. Illegal logging and related trades of stolen timbers, that is happening all over the world. In addition to that, there are some following recognized environmental problems we have, like greenhouse effects, global warming, climate change, loss of biodiversity, habitat and extinction of species. Since the first animal killed in the universe, since now we can say that 250 animals and the species of the birds becomes extinct. Environmental pollution we are facing here, and water pollution. We cannot recognize here Yamuna, either it's a sewage or the river. Acid rain, depletion of natural sources, ocean acidification, and deforestation for timber and for housing. We can say that green criminology have given an initial impetus to prevent the environmental crimes. How we can assess the environmental crimes? We have the review on development of international environmental criminals law. Eco-globally criminology provides a platform or framework to understand global environmental problems and issues in criminology. All the national and regional laws laid on the topic of environmental law are a branch of public international law created by international bodies and organizations with a collective arrangements or mutual understanding of two or more states. we can say what kind of international legal framework we have to curb this type of green crimes. We have United Nations Environmental Program, UNEP 1972. That is the outcome of the Stockholm Conference 1972, held from 6 June to 23rd June 1972 in Sweden. The Global Environmental Protection Action Plan was divided into 3 major steps: the Global Environmental Assessment Program, environmental management activities, the international measures to assist national and international assessments, and management operations. What other major outcome of this Stockholm Conference is that Rio Declarations, World Summit on Sustainable Development, Vienna Convention 1985, Montreal Protections, Basel Conventions, Conventions on Biological Diversity, Cartagena Protocol, UN Framework Conventions on Climate Change, UN Conventions on Combat Desertifications, UN Conference on the Law of the Sea, Sites for Life and Natural Sources, Nagoya Protocol, the Conventions on Conservation of Migratory Species of Wild Animals, the International Treaty for Plant Genetic Resources of Food and Agriculture, World Heritage Conventions, International Timber Trade Agreements, Conventions of the Conservation of Antarctic Seals. Various sections and articles of these conventions are mere advisory. They are not obligatory. So this is the major reason that the organized crime rackets they go escape from the nest of the from the prosecuting agencies or investigating agencies. We have some we can find here that in the Vienna Convention 1985, the transnational agreements also insist on states to cooperate mutually and strictly implement specific legislative and administrative rules, regulate and activities which produce detrimental effect on ozone layer. Montreal Protocol 1987, that is also related to ozone depletion substances. Basel Convention, that Article 4 of the agreement throw a general obligation on state parties to prohibit the export and import of the dangerous waste and enforce responsibility to ensure all legal compliance to reduce the trade of hazardous waste and provision adequate disposal facility and management of such hazardous waste. Article 4 and Article 9 are known to be the most important provision of these conventions, but they are just only to advisory. They give just advice to the nations. They are not mandatory or obligatory. They doesn't provide how to proceed with the prosecutions, how to investigate the crimes, and how to criminalize and mitigate the factors. International conventions on the regulation of whaling as to curb the illegal and unreported fishings. Another is the ITTA, that is called International Tropical Timber Agreement 2006 to stop the illegal trafficking and trading of the timbers. And another is the Conventions on Biological Diversity 1992, Cartagena Protocol on Biosafety 2002, and Nagoya Protocol to access the benefit sharing 2010. What is the basic objective of these two international legal instruments? To safeguard the biological resources, warranting justifiable use of biological diversity and its component, fair and justifiable distribution of the benefit arising from the utilizing of the genetic resources. We can find that during in the South Africa, they are very dense in forest areas. That is also a major factor of we can say that the trade related to loggings, or we can say that illegal loggings. Other international agreements like the Stockholm Conventions on Persistent Organic Pollutants that's held in 2001. What is the basic aim of that international agreements? The instrument provides education, restrictions, and controls over persistent pollutants, productions, and their uses. The International Conventions for the Prevention of Pollutions from Ships, 1973. That is the convention affords provision to preserve marine environment for eliminating oil transport ships, backdowns transporting oil and other harmful substances, and minimizing accidents due to the oil spillage. The Rotterdam Conventions, that is also related to the hazardous chemicals and pesticides of the international trade, 2004. And ICC, that is called International Criminal Courts, in 2006. International Criminal Courts started taking the case related to environmental harms. When we critically analyze the effectiveness of the international environmental legal paradigms, we will find that it is a very complex issue to include general provisions of international environmental legal frameworks in domestic laws. Why? The worth of these provisions depends purely upon the intentions and discretion of the participant state and their law-making authorities. We can control them, but it is the will of the state and individual also. Whereas all the international law that empowers the state in order to implement rights and responsibilities, but international environmental criminal law imposes obligations directly on individual groups and organizations because environment is a core subject. International treaties and agreements provide penal provisions, but doesn't constitute an offense, or they are not criminalizing the conduct. Agreements insist the parties only to bring penal provision under the domestic legal regimes. The international and continental agreements, treaties and laws discuss certain acts that could be considered as crimes, but in fact there is no exact treaty or codified criminal law for criminalizing environmental harm. Detailed provisions included in the international agreements and treaties more imposes advisory responsibility on the individual state to criminalize certain unruly environmental acts. Some of the criminal activities that produces harmful effect on the environment are recognized under the criminal law, but most of them goes unnoticed or unidentified. Why? Because due to the scare detection and reporting, lack of penal provision, lack of appropriate environmental law, inefficiency of enforceability, expertise agency, and lack of resources, etc. It is indispensable to understand the concept, meaning, definition, and dimension of the environmental crime. It has been observed that we have very few strong detection agencies like Interpol. We have a not so strong network that is used to curb and prosecute this kind of green crimes.
Mr. Kumar, could you kindly sum it up because your time is up and we have other presenters also lined up.
Sorry, just give me a minute. What are the suggestions? With the suggestions, I want to sum up my research papers. There is a need to define the idea of the environmental crimes at global instruments. Municipal laws need to be clearer and more specific in the legislation which have concern about the environmental protection. It is need of the hour to adopt modern technology and scientific approaches to mobilize data and information related to criminal worldwide in order to overcome from the lacuna of the information and global agencies. Portrayal of specific legislation and codification of the existing environmental criminal law. All legal instruments relating to environmental protection have to be restructured with the aim to provide deterrent punishments. Express green courts are to be provisioned for fast trial apart from the green tribunal, and one most important aspect, that is the will of the state and individual that is desired to curb this kind of crimes. Thank you very much.
You have in 15-12 minutes, you have spoken entire international environmental law. So there is no need of further presentation. But yes, the idea is good that the ecocide should be prosecutable. Prosecution of. There is one convention, INMOD convention, perhaps you missed it, environmentally modification technique, that somewhere addresses this concern, ecocide. And it is at nascent stage that the ecocide, still writings are coming up on ecocide. Christina Boyd, she has taken up this responsibility and she has to prepare a draft. Then it will take I don't know how many years. Then it will come under the lot of preparatory stages are involved. Then we can say that the ecocide is under the International Criminal Court. But yeah, it is the individual criminal responsibility with respect to ecocide is needed. In this regard, your contribution, your effort is valuable. Thank you very much.
May I now call upon Ms. Ravanit Sandhu if she's here? I believe she's not here. In case she comes, later we can have her. Then Mr. Chayan Chakravarti from West Bengal National University of Juridical Sciences. You have the floor, sir. He will be speaking on critical legal analysis of climate refugees of Bengal Delta. Thank you, sir.
A very good morning to one and all present in this session, respected chair, panel, dignitaries, delegates, and my dear students. I am here today going to present my research paper, A Critical Legal Analysis of Rights of Climate Refugees of Bengal Delta. Now, Bengal Delta. What is Bengal Delta? All of we know it is nothing but a Sundarban. 30% in India, 70% in Bangladesh. But today, I am not here to present the topography, geography, historiography of Sundarban. Little bit different thing I will portray today before this panel, before all the dignitaries and delegates over here. The climate refugees. This is actually my research topic. Who are the climate refugees? According to Refugee Convention 1951, this term is not enacted. We don't know why. Today climate change is inevitable. The proposition, no climate change, no climate refugees, in its literal sense, is too idealistic to be a reality. Now, if we go through the definition of climate 1951 Refugee Convention, the cornerstone of international refugee law defines refugee as individuals who have fled their countries due to a well-founded fear of persecution based on race, religion, nationality, political opinion, or membership in a particular social group. Climate change-induced displacement does not neatly fit within this definition, leaving climate refugees in a legal limbo. Now, two things are there. If I will take the example of Bengal Delta, there can be the climate refugees or internally displaced person. Why? If some people cross the border from Bangladesh to India, then can we term them as climate refugees? And if some people are migrated from different parts of the Sundarban to the Sagor, Pathor Pratima, or any other area that I will come later, then we can say that they are the climate-induced displacement. Now, impact of climate change in Sundarban: increasing temperature, rising sea level, deforestation, and rising salinity. It is one of the important factors. The Sundarban is celebrated as a World Heritage Site recognized by UNESCO in 1987 and Sundarban of Bangladesh in 1997. But 7.2 million inhabitants confront as a part of everyday life a wave of slow onset and sudden onset climate stress and socio-economic vulnerability that lead to them migrate from the region in search of work to adapt their hostile living condition. Now, here I will stop and I will give some empirical data. I have done 3 parts in my empirical study. First phase as Sagor Island, 14th to 20th of February 2024. Second phase as Sundarban, 1st to 10th March of 2024. Third phase as Sundarban, 26th March to 3rd April 2024. First phase as Sagor Island, visited Kamalpur village under the jurisdiction of P.S. Sagar. Second phase visited village Kurmimari and Poroshmoni under PS and PO of Sundarban Coastal, and all the details of my empirical study are here. Visited Sukumari number 1, PS Lairipur, Dayapur, Emlibari, Mitrobari, Anandapur, Sudhangshupur, Sadgachiya, Chorghari. Now, what I will going to say, this respected panel, chair, and all of you are just stunned. The thing is that I find only one cyclone relief center for all this district. Just think. And when I am visited the Sagor Island, I see at least 10 families, yes, believe me, at least 10 families are doing their house newly because they have lost everything in a Ghoramara and your Lohachara as well as Bedford Island. Just think, we are here having a great lunch. I am delivering the lecture and the people over there, just they are doing their house newly. They have lost everything. Believe me, sir, they are just they just think that I am from the central government or state government, and they cry as a large. They said, "Do please something. Kichu to korun amader jonno." They have told me, sir, and I cannot, what to say on that point of time. I am just depressed. What I am doing? This is my PhD? This is my paper presentation? Because we are the social engineers, according to Roscoe Pound. We have to do something for them. Now, national policy. National Action Plan on Climate Change and State Policy. West Bengal State Action Plan on Climate Change. This is not working. Now, scope in India, model of a refugee asylum seeker, refugee asylum seeking protection bill, asylum bill, but no outcome for climate refugees. There is no outcome. Now, my recommendation is that amending the present refugee convention is first. Secondly, new legal framework dedicated for climate refugees. But that is not the issue. We have to have an effective implementation. We need a hard law for these haplessly hopeless citizens of India or inhabitants of the Sundarban or Bengal Delta. We need the effective implementation. There is no implementation, believe me. If the saline water enter into their cropping land, they told me, sir, we cannot do agriculture for next 3 or 4 years if the saline water entered into their land, and all the rivers are there as a saline. I conclude in this way that climate crisis is the biggest threat to our survival as a species and is already threatening human rights around the world, according to UN Secretary General Antonio Guterres. So we can take a pledge today. As a citizen of India, we can do anything and everything for this hopelessly hapless inhabitants of Sundarban. Thank you very much.
Yeah, it is just said. I think that that's a very sensitive portrayal of Sundarban. So I like that, because recently there is a piece in the Hindu that there are two, that either people in the Sundarban are being killed by tiger or climate change. These are the two that are killing them, people in the Sundarban. And there is one area that is source of employment. It is a bee. That's it. And people are having employment through that route. So I like the concern that you have raised, that the climate refugees, that it's an uncharted territory still. There are a lot of concerns, but there is no serious effort at the international level, no protocol. There is a discussion that we have to have a protocol to the Refugee Convention, then we can have this, we can address it. So we can wait for the protocol. Yes, sir. Otherwise, the states can, on the basis of their internal laws, I will share some literature, and there is a work. Yeah, there is one work by Professor Frank Bierman. Please read it. Okay. Thank you very much.
Thank you, Dr. Sadat and Dr. Chayan Chakravarti. I now move on to the next speaker, Mr. Atul Yadav and Dr. Amarendra Kumar from the Faculty of Law, University of Delhi. They would be speaking on establishment of loss and damage funds for climate crisis, construing a new global commitment under Sharm el-Sheikh climate. Yes. You have the floor, sir.
Good afternoon, everyone. Respected chair, panelists, esteemed delegates, and my dear friends. I am Atul, and the topic of my presentation is the establishment of the Loss and Damage Fund, construing a new global commitment under the Sharm el-Sheikh Climate Agreement. And I shall also be speaking on behalf of my sir, Dr. Amarendra Kumar, who is also the co-author. Now, coming to the overview and the objectives and structurization of the paper, I'll be first examining the existing legal basis for the loss and damage liability. Secondly, I'll be analyzing the new commitment under the Sharm el-Sheikh plan, which created basically the loss and damage fund. Thirdly, I'll be exploring the future strategies for transforming it from rhetoric to reality. Next, I'll be accessing the potential effectiveness of this fund and the potential challenges as well. And lastly, I'll be proposing certain actionable steps for ensuring its successful implementation and sustainability. Now, dear friends, climate crisis is no longer a distant threat. It's a growing and present danger. Now, our previous learned friends, Sir Praveen Kumar and Sir Chayan Chakrabarti, gave some real-life examples from Sundarbans and how there is a breathing issue in our capital city and the pollution of water of river Yamuna. And I also add to that by giving certain other statistics compiled by authoritative international organizations that highlight the grave issue of climate crisis all over the world. And some scholars like Rosemary Lister have even termed it a climate emergency, not just a climate crisis. Now, the 6th ARC report of the IPCC 2022, it highlights extreme weather events, erratic monsoon patterns, rising sea levels, heat waves, and other climate-induced disasters all across the world, but disproportionately impacting the developing nations. Now, many of the small developing island states, they are also facing existential threat. And 5 Pacific islands, some were habitated. They have already been submerged, according to a Guardian report. Now, these are certain empirical data from authoritative sources showing the frequency of natural disasters, that how it has increased from 1980 to 2022. Then we have the mean temperature change, 1961 to 2022. As you can see, it has risen manifold. Change in mean sea level. And not only the developing countries or the least developing countries are being impacted, negatively impacted, but also the developed countries as well. As you can see from this data, this figure offers the annual economic losses caused by the weather and climate-related extreme events in the EU member states. Billions of dollars of losses. Now, coming to the concept of loss and damage. So, scholars have defined loss and damage as adverse effects of climate change that is beyond the adaptive capabilities of people and regenerative and carrying capacities of nature. And it involves more than that which can be reduced by adaptation. That's the UNFCCC definition 2014. Now, the adverse effects of climate change are not just limited to rise in global temperature or sea level rise, but it includes damages to biodiversity, infrastructure, agriculture, economy, cultural heritage, natural habitat and indigenous practices and peoples, etc. Now, there have been certain debates and contentions regarding the scope of the loss and damage. So whether it should include only the loss and damage that have already been experienced, or it should also include the prospective and future cases of loss and damages. As has been pointed out by a learned environmental scholar, Daniel Puig. Now, there have also been growing debates about the distinction between the losses and damages. So, for instance, Lusk has called the losses, he meant by losses irreparable damages, and while by damages he meant reparable damages. Now, the disproportionate impact of the climate change have been in debates since decades. Now, Brundtland report of 1987 also recognized the differential impact of climate change on the developed and developing nations, and consequently, it asked the developed countries to provide funds and technology to developing countries to build their capacities and capabilities to cope up with the climate change. Now, the legal basis for loss and damage. So now there are both soft laws and hard laws. For a long time, it used to be soft laws, voluntary contributions. Principles like climate justice, equity, historic responsibility, polluter pay principle, principle 22 of the Stockholm Declaration, CBDR, principle 7 of Rio 1992. And now in the Warsaw International Mechanism of 2013 and the Paris Agreement also acknowledged loss and damage. Paris Agreement is specifically provided that global stockade that it proposed, it should take into account the loss and damage, and it should consider the information related to loss and damage. Now, the Sharm el-Sheikh Agreement of COP27 concretized all these efforts in the form of the Loss and Damage Fund, which was part of the agenda item 8F of the conference. Now, coming to the rationale and details of the fund. So, the Sharm el-Sheikh implementation plans includes all these details. It just broadly provides broad outlines, not goes into much details, but it includes finance, tech transfer, capacity building, and other support mechanisms. And it also provided for a transitional committee to make recommendations regarding the structure and operation of Loss and Damage Fund at COP28 Dubai, UAE. Now, the Loss and Damage Fund under the Sharm el-Sheikh Agreement operates within the broad framework of the Article 9 of the Paris Agreement. It is significant because for the first time, a kind of a legal commitment has been made to compensate the developing countries or the least developing countries who have faced the adverse effects of the climate change, not of their own making, but by the historic emissions by the developed nations. Now, a case study, Pakistan-led G77 officially demanded loss and damage compensation within that conference itself, COP27 Egypt, but it was rejected by other nations. Now, coming to the subsequent developments after the Sharm el-Sheikh, that agreement. Now, transitional committee has been meeting again and again, and the developments have not been very encouraging. For instance, the transitional committee 4 meeting, it concluded with a stalemate on issues like like who should host the fund and the climate reparations, the eligibility criteria, etc. However, the transitional committee meeting 5, it drafted certain recommendations and it sent to COP28. Now, COP28 that concluded in UAE, Dubai. So, on the very first day itself, they disagreed on a loss and damage fund to be administered by the World Bank. In terms of the funding, UAE and Germany each pledged 100 million to the fund, UK 75 million, and similarly other countries pledged. But if we look at this amount, it's still very meager amount compared to because we have had more fundings with the, like for instance in the Global Environment Facility that was established way back in 1992 with the Rio Convention. Now, COP29 Baku, which is planned in November 2024 in Baku, Azerbaijan. So, Azerbaijan has introduced this concept of Climate Finance Action Fund, and hectic negotiations are going on regarding this aspect, seeking $1 billion in annual contribution from fossil fuel producing countries and companies. Now, coming to the potential challenges, the first and foremost challenge is the funding related challenge. So, various studies have pointed a shortfall in terms of what's actually needed and what has been gathered so far, as you can see in the data provided in this slide. And then there are uncertainties regarding the size of this fund. There has been no consensus, and previous attempts have been quashed due to the pressure from UK and Australia. So the current arrangements it urges developed nations to provide the fund without any clear commitment or framework. There are governance and administrative challenges, then legal and political challenges as well. For instance, attribution of this liability, because these are sovereign states. No state would readily agree that we are responsible for that particular loss and damage in any developing country. And for instance, at the COP28, US Secretary of State John Kerry, he bluntly refused to pay any climate reparation under any circumstances, as reported by BBC 2023. Now, coming to some actionable steps for the success of the Loss and Damage Fund. So, number 1, operationalization strategies. So, there should be some local participation, bottom-up approach rather than a top-down approach. So, first and foremost, they should establish the regional offices to take into account the local and regional factor. And certain innovative financial mechanisms should also be evolved, like climate bonds, carbon taxes, CSR initiatives, to diversify and stabilize the funding streams. There is obviously a need for international cooperation and the need for continuous monitoring and evaluation. And GEF, Global Environment Facility Result-Based Management System, has already yielded positive results in this regard. Now, concluding, Loss and Damage Fund is a milestone in climate justice. However, its success depends on several factors like effective governance, sustained funding, international cooperation, and global solidarity. And on the global solidarity aspects, because India being an ancient civilization, it has certain value systems that can assist achieving that, like Vasudhaiva Kutumbakam, one earth, one family, one future. That was the theme of the G20 summit hosted in India. And also, more than that, a recognition that loss and damage is not just an environmental issue, but a matter of human rights and justice as well. In this regard, the upcoming UNFCCC COP29 in Baku, Azerbaijan will be crucial for fund's evolution. Now, lastly, I end with this quote of Honorable UN Secretary General, that success of climate finance depends on our ability to connect global resources with local realities. Thank you so much.
Thank you, Mr. Atul Yadav. We have 3 more distinguished speakers with us, and as per the program, 30 minutes left with us. So I would now call upon the next speaker on my list, WGT Yashoda Tilakratne, and the 3 speakers that we have, I would also request them here in that if they could confine their remarks to 8 or 10 minutes, that would be wonderful. So that we can have some discussion also once the speakers have made their presentation. So our distinguished colleague from Sri Lanka, you have the floor.
Yes, good morning, everybody, esteemed guests, panelists, and my dear colleagues. The given time for me, I will raise my voice on behalf of voiceless, that is on animals. Animals in international law. Necessity of stepping towards global animal protection as a legal concern is my topic. Yes, before starting the discussion, I request from all of you, just think, what if you have become lifetime prisoners of another person? And if your freedom of movement, freedom of thinking, freedom of behaving with your colleagues is restricted by another person, unanimously decided by another one. Yes, animals are the hidden victims of human behaviors and human acts. Animal law basically can be divided into 2 segments, animal welfare and animal rights. But here in my research, in my discussion, I'll be focusing on animal welfare because without facilitating animal protection plus animal welfare, we can't discuss on animal rights. So what is animal welfare? To be simply defined, according to an American Veterinary Medical Association, if an animal is in good state, if it is healthy, comfortable, well-nourished, safe, able to express its innate behavior, and if it is not suffering from unpleasant states such as pain, fear, and distress, we call it as animal welfare. And also, according to the World Organization for Animal Health, they say that the treatment that an animal receives is covered by other terms such as animal care, animal husbandry, and humane treatment. In its simplest form, I would say animal welfare is nothing more than the humane use of animals. As per the objectives of my research, I'll be identifying the importance of animal welfare within law, and I'll be analyzing the existing international legal regime for the welfare of animals, and I'll be evaluating the areas of animal welfare law where it should be developed, and I'll be suggesting possible recommendations to uphold animal welfare at international level. As per the methods and methodologies that I have used in my research, this is basically a qualitative method, and black letter law have been approached. And both primary and secondary sources have been gathered in developing my research objectives. Yes, animal welfare science has increased understanding and acceptance of animal welfare and animal behavior.
Most importantly, science has now confirmed that non-human animals who share our planet with us are sentient beings. But what about law? They have actually, in science, they have accepted that animals or non-human animals, they have consciousness, feelings, emotions, perceptions, etc. And also they have accepted that they have the ability to experience pain, suffering, and states of well-being. There are many science-based treaties, conventions, regulations, directives that contribute for the welfare of animals in the perspective of science. But still, in the regime of international law, there is a huge gap prevails still, because there is no comprehensive or stringent, there's a huge lack of stringent law in order to protect animal welfare and also animals. So the concern of animal welfare is being now debating in many regional and international forums, yet there is a lacuna, as I said earlier, of stringent legal regime for the welfare and protection of the animals worldwide. So there are some handful of institutions where animal concerns, animal welfare, animal protection in various dimensions have been recognized. To name a few in my slides, World Organization for Animal Health, we call it as also OIE. It's one of the major international drivers where they go towards animal welfare among the regions and where it sets global standards for animal welfare. And then United Nations Environment Programme, UNEP is, although it works, does not include animal welfare per se, it does include biodiversity and sustainable consumption, where animals and animal welfare, animal protection is discussed. Then the World Health Organization. The World Health Organization is also important in deciding animal welfare, where it has the mandate for stray dog control. They have initiated many projects on protecting welfare measures of stray dogs, which is also covered by an OIE international standard. It has coordinated a number of pilot projects on stray dog control around the world. And very specially, I have drawn out here the European Union, the region of European Union. They have taken actually very possible measures to protect, and they have opened up groups to discuss animal welfare as a legal concern. The European Union is the most progressive in terms of including animal welfare in its sphere of policy work. So it has recognized animals as sentient beings very specifically, and it has developed an extensive body of animal welfare legislation which has improved animal welfare standards across their countries, and it contributes significantly to raising the profile and awareness of animal welfare at an international level. I have drafted few directives and also some of the conventions were initiated within the EU countries. So I have moved on to my concentration next about the 5 freedoms of animal welfare. 5 freedoms of animal welfare are one of the universally recognized animal welfare concerns that includes or that open up avenues of animal welfare. It includes freedom from hunger and thirst, freedom from pain, injury, and disease, freedom from fear or distress, freedom from discomfort, and finally, freedom to express one's normal behavior. So you see, both physical and mental touch have been given through the 5 freedoms of animal welfare as a concept. So this actually can be taken as blueprints when deciding the international legal regime for the protection and welfare of the animals. So as per the conclusion and recommendations, based on my findings, it is It is to say that animal welfare is not currently regulated by a single comprehensive international law instrument. And there are prevailing frameworks in international law that address animal welfare do not meet the hallmarks of an effective global protection regime, including comprehensiveness and enforceability. To name a few, Universal Declaration of Animal Rights and the ones that I have mentioned in my PowerPoint. So, 5 freedoms of animal welfare is to be considered as the overall guiding principles, and I highly recommend. We are in a position and we are in a high need of implementing an international convention for the welfare and protection of all types of animals. Within that, we can go for some protocols to the treaty. To name a few, Protocol for the Care and Safety of Wild Animals, Protocol for the Safety and Welfare of Domestic Animals, Protocol for the Protection of Aquatic and Exhibit Animals, Protocol for the Welfare of Livestock and Scientific Animals. So within that even, I do recommend the recognition of animal sentience, and then the strengthening of human responsibility and the duty of care within the legal definitions. Not only that, expansion of education and research on animal welfare should be strengthened. And why not about the judicial? Role of judiciary also should be strengthened in order to uphold animal welfare and animal protection within the international law. So thank you very much. I'm going to widen up from that, and we have a big duty towards animals. Thank you very much.
Thank you, Yashoda ji, for giving very effectively and very efficiently voice to voiceless. And let's all join her in giving this voice to voiceless. The next speaker on my list is Monali Gandhi from Nagpur. She will be speaking on environmental preservation responsibility across generations. Thank you, Monali ji, and you have the floor.
Honorable Chair, esteemed panelists, and distinguished delegates, and all the members of ISIL who are present here, a warm good morning to everyone. I, Monali, presenting on the topic environmental preservation responsibility across the generation. It's a privilege to be here today to discuss an issue that not only affects us but will resonate with future generation climate change. As we gather, it's clear that this challenge is beyond just a scientific or environmental concern. It is a moral one with deep ethical implication for the generations that come after us. Today, I will talk how our current activities are shaping the environment, the concept of intergenerational justice, and the measures we need to take globally and locally to mitigate the effects of the climate change. Let us start by recognizing a fundamental truth. Earth is a finite resource, and human activities are depleting it at an alarming rate. What we are seeing now isn't just shifts of weather pattern, but long-term environmental degradation. Global warming is the heart of this issue, and the greenhouse gases we emit are the culprit behind the rising temperatures. As my people explores the burning of fossil fuels, deforestation, and sustainable and industrial practices have thrown Earth's natural balance into disarray. But the bigger question is, how does this affect not just us, but the people who come after us, our children, their children, and beyond? At the heart of this conversation is the idea of intergenerational justice. What we do today impacts future generations. It's a concept we can't afford to ignore anymore. We have inherited a planet that provided resources and a life for millennia. But the question is, will the future generations inherit a planet that is livable? Intergenerational justice isn't a theoretical idea. It's about fairness, responsibility. If we continue on this path of environmental destructions, we deny future generations the same opportunity we have had: clean air, fresh water, stable ecosystem. This is not just unfair, it's morally wrong. From a utilitarian perspective, it's about ensuring that the greatest happiness isn't just for those of here today, but for the greatest number across the time. We have a responsibility to act, not because we all directly face all the consequences, but because we are shaping a world that future generations will depend on. So, how we are impacting the planet today? My research focuses on several critical areas where climate change is already affecting societies, economies, and ecosystem. Rising sea levels threaten coastal areas and island nations. Extreme weather pattern, more frequent hurricanes, heat waves, drought are becoming the norms. These aren't the problem of distant future. They are happening right now. And the ripple effect of climate change don't stop there. We are talking about food diversity, displacement of population, loss of biodiversity, and economic destabilization. The stake couldn't be higher. The global community has recognized this threat and have been significant efforts to address it. Frameworks like the United Nations Framework Convention on Climate Change, the Kyoto Protocol, and the Paris Agreement were developed with the goal of limiting global warming. While progress has been made, as I outlined in my paper, the challenge remains significant. We need more than agreement on paper. We need sustained action. This is particularly important when we talk about the most vulnerable nations, which contribute the least to climate change but suffer the most from its effect. So, what can we do to address this? The provision and execution of fiscal policies aimed at mitigating climate change must be a top priority of finance ministers. They should alter the tax code and fiscal policies to achieve this in order to deter carbon emission from coal and other fossil that emit pollution. There is hope for higher future in order to incentivize and business to curtail their energy consumption and transition to sustainable energy source. Government will have to raise the cost carbon emissions. The cost effective potent instruments are carbon taxes, but only if they are applied fairly and in a way that promotes economic growth.
By human activities, not only finite resources of the earth are being depleting day by day, but by the emission of the greenhouse gases is leading to biodiversity loss too. It's a global challenge that transcends the national boundaries and generations. These consequences will have an outside impact on future generations who will inherit a planet rather than blue planet with fewer resources and more environmental instability. There is intergenerational responsibility for protecting the environment. In order to mitigate the current environmental damage and conserve natural resources, the current generations must act immediately by focusing and using renewable energy, education, sustainable agriculture, reuse bags and bottles, and avoid plastics, go meatless and eat local, plant indigenous trees. These methods and become an active citizen by sharing the knowledge with older generations. Together, we can make sure that future generations and ourselves have a sustainable future. Furthermore, as environmental challenges go across national borders, governments need to establish forums for international cooperations. Long-term economic gains can result from environmental conservation, even though it may have initial high cost. The biggest causes of environmental deteriorations are the industries. Corporate social responsibility, when combined with regulations, it can promote green technologies, renewable energies, and sustainable policies can boost economic growth, reduce reliance on fossil fuels, create jobs, and also help to mitigate the problem of climate change by implementing proactive policies. Environmental preservation is not only the field of governmental and cooperations. Every individual plays an important role in reducing their carbon footprints, conserving resources, and advocating for sustainable policies and practices. In order to encourage a sense of responsibility in both individuals and communities, it is imperative to increase knowledge of environmental challenges and support environmental educations. People may support sustainable practices and may educate decisions if they are aware of how human activity and environment are intertwined. Climate change is no longer the main topic. It has become a global crisis as the average temperature of the world continues to rise. The effect of climate change are becoming more apparent. We are already experiencing more natural disasters, species extinctions, rising sea levels, and loss of human life. Therefore, urgent climate change is not only important but also necessary for survival of humanities. In conclusion, the fight against climate change isn't just about preserving the resources for ourselves. It's about ensuring that future generations inherit a world where life can thrive. Our moral duty is clear. We must act with urgency and determination to protect the planet. The choices we make today on an individual, national, and global level will define the future. And while the task ahead is daunting, it's also the opportunity for us to come together as a global community to prioritize sustainability and to leave a legacy that we can proud of. Thank you for your attention, and I'm grateful to the organizing team for providing opportunity to me. And in advance, happy Diwali to everyone, and Remember that thing while using or bursting the firecrackers. Think about the climate change. Thank you so much. Have a nice time.
Thank you very much, Monali ji. I now call the last speaker on my list, Dr. Meghraj from Faculty of Law, University of Delhi. He will be speaking on exploring the Indian efforts on climate change and obligation under international environmental law.
Thank you very much, sir. A very good afternoon to Chairperson Dr. Shikhar Ranjan, Dr. Anwar Sadat, Professor Manoj Sinha, my colleagues, fellow participants, and other members of ISIL. It's a privilege for me to speak on this subject before the doyen of international law, Professor Manoj Sinha, Anwar Sadat, and Shikhar Ranjan sir. My paper is on exploring the Indian effort on climate change and obligation under international environmental law. I wrote this paper along with Dr. Brajesh Singh. He is the assistant professor in Allahabad University. The Earth climate has been significantly impacted by the human activities, industrialization. And the global community got consciousness right from 1972, when the first conference under the aegis of United Nations was convened at Stockholm Conference. India participated in that conference and shows the seriousness. But that was the soft law. And from there to the World Charter and finally to the United Nations Conference on Environment and Development in 1992. One of the major outcomes of this Earth Summit in 1992 was United Nations Framework Convention on Climate Change. And as per the convention, when the minimum number of signatories signed that it will come into the force, so in 1994 it came into the force, and it was, as per the convention, decided to have every year, because climate change is a very serious issue and it affecting every nation, small or large. So from 1995, these COPs keep on going. And after that, there are some other documents that also came into existence, like Kyoto Protocol 1997, Paris Agreement. All these commitments, and from COP 26, 27, 28, the pledges that India took: National Determined Contribution, Green Credit Program, International Solar Alliance. To cope up with this and to implement all these commitments and pledges in the domestic jurisprudence, India has taken various steps. So my paper is basically to cover those steps that India has taken. And I have divided this paper into two parts. One is the steps taken by the government to reduce the effect of the climate change, to mitigate the climate change. And second is the role of Indian judiciary to recognize and save the people of India from the adverse effect of the climate change. So first, I'm going to make the presentation related to the Indian government efforts. One of the first effort is National Action Plan on Climate Change. The previous speakers also spoke on that, so I will not speak much on that, but few things I will speak. One is under the National Action Plan on Climate Change, that was a comprehensive plan covering 8 agenda. National Solar Mission, where a target was set up by the government to create the energy from non-fossil fuels to the 100 gigawatt by 2022. National Mission for Enhanced Energy Efficiency, National Mission for Sustainable Habitat, National Mission for Sustaining the Himalayan Ecosystem, National Mission for Green India, National Mission for Sustainable Agriculture, and National Mission on Strategic Knowledge for the Climate Change. In India, our constitutional system allows that the government can put any bill and the parliament can enact any law to fulfill the international obligation. Also, we have the provision that India must have the respect for the international law. So in line of all these commitment and the mandate from our constitutions, the India has enacted the law Energy Conservation Act 2002, and that was amended through the Amendment Act in 2022. Under that, Bureau of Energy Efficiency was created just to promote the energy conservation. Because the climate change, the one of the reason is that we using the fossil fuels to meet our energy demands. And it's very important to save the energy, to conserve the energy. The second thing is the promotion of the renewable energy, and India was pioneer in that. International Solar Alliance, ISI. India has the partnership with various countries. With France, India has launched this ISI to aim to mobilize 1 trillion investment in 2023 to promote use of solar energy globally, particularly to the developing countries. Second is to create green energy corridor with aim to synchronize renewable energy source with national grid to enable smooth integration of green powers in the country's electricity mix. Various schemes by the government like Ujjwala, where the poor people before that used to use all those fossil fuels to meet their demand in cooking the food. But with the Ujjwala scheme, the focus was providing clean cooking energy LPG to the household, reduce indoor pollution, improving health, and also to mitigate the climate change. We all know that the carbon can be shocked by the environment with the plants. So the afforestation and conservation. The India's program like Green India Mission and initiatives such as the Compensatory Afforestation Management and Planning Authority, CAMPA. This is to increase the forest cover, to planting the more trees throughout the cities and villages, to restore the degraded land, and to make our Mother Earth so that the carbon can be soaked. The next is the adaptation measure. Recognizing the vulnerability of climate change, India has undertaken significant major climate resilient agricultural program. Under that, the government of India has launched the Pradhan Mantri Fasal Bima Yojana for insurance to farmer against the climate risk. National Disaster Management Plan, NDMP, the National Disaster Management Plan, a comprehensive strategy to reduce the risk of disasters, because loss and damage fund, someone has talked about that. And due to the change the climate conditions, there are more disasters, we all know. Another one is, that electricity mobility and green transport. FAME, faster adoption and manufacturing of hybrid and electric vehicles. The government of India organizing different programs, symposium to make the people aware and to use the electric vehicles. Also, in various other statutes, also the government is making changes, like in the Companies Act 2013, the concept of the CSR, Corporate Social Responsibility, Section 135. And there, as per the Schedule 7, there are some areas where the corporate firms, corporate person, they can also invest and also, save the earth. But there are some challenges. One is still India has the dependency of coal, heavily reliant on the coal. Another is the financial need. India has emphasized need for climate finance and developed nation to support its energy transitions and climate adaptation. Now I will cover the second thing is about the Indian judiciary role. There is a very celebrated judgment from the European Court of Human Rights, where the European Court of Human Rights in the judgment of Varian, Sijwaj and others versus Switzerland, the court ruled that Switzerland has violated the European Convention on Human Rights by not taking enough action to combat the climate change. And this judgment was very celebrated from April 2024. But my dear friends, before 1 month, the Indian Supreme Court in March 21, 2024, a well-celebrated judgment of M.K. Ranjishin and others versus Union of India and others has ruled out that right to life and equality in our Indian Constitution include right to be free from the adverse effect of the climate change. So when there is a dispute, when there is a conflict, because this case was with respect to great Indian bustard and bird in the Gujarat, and with the mission of solar plantations and all this wiring, it creates the problem for this bird. But the Supreme Court has ruled that it was based on the hardship faced by the communities that are vulnerable to climate change, and due to their geographical and economical circumstances, court recognized that it's the duty of the government, not only under the international obligations, but incorporating this principle under the Article 21, which is a fundamental right, and one can seek that remedy under Article 32 of the Indian Constitution for redressal. So with this change, Indian Supreme Court is the far ahead. So with this, I conclude that despite challenges such as reliance on the coal, financial constraints, complexity in implementing the climate strategies across the diverse and populous country, India continues to demonstrate global leadership in addressing the climate change. The nation's ambitious target, including reaching net zero emissions set to 2070 and increasing renewable energy capacity, so cost its long-term vision of building a greener and more resilient future. Thank you very much for listening to me. Thank you, sir.
Thank you very much, Dr. Meghraj, for exploring the Indian efforts on both counts. Our theme for this session is International Law's Role in Tackling Climate Change. And we have, fortunately, amongst us, the ace Indian negotiator on the topic of climate change, Dr. Luther Rangreji. And I could not resist requesting him to share his thoughts how, as Indian international lawyer, he has been at the forefront of negotiating climate change obligations. And sir, I would request you to come and share your thoughts from here. And thereafter, my colleague, Dr. Anwar Sadat, will sum up the events, some of the proceedings. And I know that I am coming in your way of right to food, because our organizers have provided very delicious food. But let's first hear two of our eminent speakers on the subject. Thank you, sir.
Thank you, Shikhar. I'm not going to tell you what happens in the COPs. Everybody knows they are open secret. But what is important to understand is that climate change is not a pollution issue. I think many of the scholars around look at climate change as a pollution issue. Climate change is a developmental issue. Climate change is the fights of a large number of small countries and developing countries to not only look at their right to development, but also to ensure climate justice. And this climate justice is something which needs to be provided to needy countries, developing countries, simply because of the fact that they have not contributed to the problem, the degradation of carbon budget as it exists today. I think many of the speakers whom I heard, maybe they know this, but I think you need to speak this out. I'm not going to tell you as a government person to tell you this. You have all the freedom to do this. We fight day in and day out, right from the Bali COP from 2007, 2009, the Paris Agreement, the Paris COP in 2015. and the international law that has been put in place. The problem with international law is that you don't have the problem with the law. You have the biggest problem is the problem in implementation of the law. And when you don't have the right will, the political will to implement these, you have huge number of problems. And the problems are there for everybody to see. You have, I think, if somebody asks me, the single most important issue that countries should fight for is global climate finance. Simply because you can't ask a country that doesn't have finance for its own development to start combating climate change. You can't differentiate, segregate climate change from developmental needs. This is what Prime Minister Indira Gandhi said in the Stockholm conference. That what sort of global legal order in the United Nations are you speaking about when the largest producers of greenhouse gases are not taking the lead in combating. There is an inbuilt inequity. There is an inbuilt lack of global concern. Although the General Assembly says that it's common concern of mankind, the common concern is there, and all lawyers write any number of academic articles on this and papers. You have climate change and human rights. You have climate change on economics. You have climate change and diplomacy, political science. It's a huge human rights issue. As speakers spoke about the Great Indian Bustard case and the Klimi Seniorinen case in the Swiss courts. All of these attest to some form of lack in multilateralism to bring to fruit or bring to fruition, the campaign or the fight for combating climate change. Why our country is going away? Yesterday, Dr. Sujit was speaking about this, that lack of faith in multilateralism is driving countries towards climate litigation. And climate litigation is not something that can be segregated from the larger environmental litigation you have. But then in the international sphere, it is so difficult to fix liability. Who's responsible for this? You have the loss and damage fund. You have no money in that. The challenge is the governance structure. Along with the governance structure, how much money you contribute to this. You have a huge adaptation fund. You have $300 million all that countries have provided. You may require close to $3,000 billion in adaptation. That's the biggest problem facing all developing countries. How do you adapt to the effects of climate change? You don't have any money in the Green Climate Fund. And the next COP which you have in Baku is going to speak about the new collective quantified goal on climate finance, that's called as NCQG. And the estimates from the IPCC and a number of other countries say that you require close to $4 trillion annually, not one time amount. $4 trillion annually to combat climate change and help developing countries. Now what you have is not even 48 billion. In the COP9, you pledged 100 billion, but what's been given is 48 billion, and that's not been given. That's more as chanda, It's given in the form of loans. It's given, in the form of assistance through multilateral developmental banks. You require grants, which will not, charge you interest on this. So it's quite a complex vortex. Of the politics of global climate change is more fascinating than the law on global climate change. The law is there, but the politics is more fascinating, and the politics decides how the law should be implemented. The last one thing I would say is it's very important for lawyers to look at this. You have three climate cases going on all around. You had the Inter-American Court, you had Chile and Colombia asking for climate emergency and advisory opinion on climate emergency, largely dealing with human rights aspects. Then you had the ITLOS, advisory opinion sought by small island states called COSIS, and you had a judgment this May. The order an outstanding aspect of the order is it has brought into the definition of marine pollution or the pollution of the marine environment, ocean acidification. So it has the order depended largely on the IPCC's views. Not many countries believe that that it would be something which would be implemented in letter and spirit. But it's an important contribution that the ITLOS order says that you need to take stringent, what they call as due diligence measures. Now it remains to be seen what these due diligence measures are. Due diligence measures, any student of law would say, it's those measures expected of a rational and prudent man. But then what is stringent due diligence measures? So I think somewhere the court, was over enthusiastic and the tribunal was over enthusiastic in saying that you take stringent due diligence measures. You can't put a gun at a state's head and say that you take more measures than your capacity allows you. And why should it be that the developing countries take more measures? Why should they take more measures? It should be the richer countries, which the entire law on climate change says, Article 4 of the Paris Agreement, Article 3 of the UNFCCC, all of them say that the lead should be taken by the richer countries. The third case is that's going to come up before the ICJ. It's a larger case. It can be, expected that the court would look at all aspects which are being agitated before it. Two primary questions, as they put it. One is, what is the international law on obligations, or the international law on obligations of states under customary and conventional law? And the second is, if this particular conventional laws and customary laws are not followed, not adhered to, what are the legal consequences? Most international lawyers know what are the consequences. You will say rules of state responsibility, and you'll speak about, rattle out right cases from the Trail Smelter arbitration to the Chozo factory case and a number of others that say that states are responsible. But then how do you implement this? They are advisory opinions. Do states really, say, oh, there are 2-3 court advisory opinions, let's follow them and increase the finance to developing countries? They maybe have these judgments may have a large amount of hortatory value, persuasive value, but I think it is important that states take up this issue, and developing countries as a collective whole should fight for greater climate finance and a definition of climate finance that is more grant-based and not loan-based in a COP that is going to come up. At the individual level, many of the speakers said, I think that is very important, that you should also mainstream climate change concerns in your schools, colleges, universities, and a number of other places. China uses a lot of cycles. Delhi is, in this part of the time of the year, it becomes the most polluted city in the world. I don't say this, the estimates of, the Indian Meteorological Office says. So I think, individually and collectively, you can contribute to protect the global climate and also the climate in India. Thank you, Shikhar.
Thank you very much, Utha sir, for very succinctly bringing to us the core issues related to climate change. Now I open the floor for discussions if there are any. If we have any questions from the floor, we have our friend Deep Shikha ji, and then there is a young scholar from behind, Deep Shikha ji.
Yeah, Deep.
Chaturvedi sir, first Deep Shikha ji, and then Chaturvedi sir, and then the colleague behind.
Thank you. Just agree, sir told that the politics decide how law can be implemented. So just and there was a discussion on representation on the technology method for the climate change. So just I wanted to ask that whether 2023 decision regarding climate change development through technology method is not serious or is actually worthful to decide through the technology method, because where electric batteries is also very damaged the layer of the earth, and that is also not recycled if we are, and that is which add to the growing worldwide. The second thing, e-waste problem will also increase through the technology method, and only 5% recycling will be there. That is more serious. Higher carbon emission is, though there is a building of the gaseous car is better, then but the technology and building of the electric batteries, that is more dangerous and damaged. So in this situation, just like example for lithium batteries. So in this situation, what is means whether it is worthful to decide for the technology method in 2023. So whether this it will be mitigate the climate pollution or climate change development, what we are running for that. So just I wanted to ask, this technology method is will damage in future, what in my opinion.
We can have first of all the comments and observations, then I would request the panelists to respond. Mr. Chaturvedi, please.
This is, I'm addressing to Tilak Ratne. Very surprising to find such a voice in this international conference. And she raised very important issues. At international level, these have not been addressed, but at domestic level, as a Delhi district court, I was known as animal judge in 1992 because of 3 judgments. One of the stray dogs case, was the other slaughterhouse cases, and one more case, where these questions were for her information, and I will share with her. There I defined our joyous gaieties and celebrations should not become horror, sorrow, and terror for innocent animals. This is compassion in action. We have in India a duty of compassion towards living creatures under Article 51G. And she raised question of five rights. The rights of those who cannot exercise rights are jurisprudentially turned into duties. When we our own children, innocent children, right to education is through us or through next friend. So this, in that judgment I will share with you, I have defined that animals are not encroacher on earth. As we are, so they are. And all their rights are to be exercised through our duties. And everyone has a fundamental duty as a next friend to protect the animals. These and many other issues, because are there, I will share with you. This is only intervention. Thank you very much for raising such a issue. Thank you.
We have another comment from behind, sir, just behind you. She has the mic.
Good afternoon, everyone. My name is Shruti, and I have 2 points and 1 comment to make. So my first question is from Momita ma'am. So disaster preparedness, I think the early warning system is very much important. So right now, and we are seeing so many disasters in a year. So ma'am, I was just asking what role could AI play in terms of data collection, which can help in early warning system, strengthening the early warning system, and then disaster preparedness. So that was my one question from her. And another question is from Shayan sir. So sir, I really appreciated your work with Sundarbans, and my question is, because you talked about salinity, so, and I've been thinking that I think that it is a very serious issue. I just want your comments on how much serious it is, how much it impacts climate displacement. And my third comment is with to Dr. Meghraj, and he highlighted the climate change initiatives from India. But at the same time, I also see that in the past few years, India has really diluted its environmental commitment in terms of diluting its environmental laws. All laws, whether we talk about water law, because it has reduced the punitive measures. So I think there should not be a disconnect where we are taking some steps, and on the other hand we are diluting laws, our own laws. So that is just one comment I wanted to make. Thank you so much.
Thank you very much, distinguished participants, for their comments and observation. I request Dr. Mandal to respond, and then Mr. Chakravarti. Thank you.
Thank you for these questions. These are very interesting and important questions. So first, I would like to answer the questions relating to 2023 technology method I'm asked. So as of now, we can say the use of technology already started, and at the international level, national level, all are trying to adopt the technologies for the climate mitigation and climate adaptation. But yes, it is also true that we don't have the global law relating to technology. Another thing is that we are also concerned about the outcome of the technology, especially the waste that will come out from the use of technology. So another emerging issue that is going on, that how to use and reuse the waste, that basically result of use of technology. So circular economy, all these things are basically proposed, that the waste can be reused, and it will not pollute the environment again, and another cause of climate change and environmental pollution. Thank you. And the second question, that is relating to the early warning system. Okay, how AI can be used. So AI basically, it compares the already existing data, okay, relating to weather, and then it predicts what would be in future, and that the future prediction that can reach through AI technology to the people. It may be the people who are living in the coastal area, or maybe the rural area, and through this mechanism they can basically take that government as well as the people who may suffer because of the result or consequences of climate change. They can adopt their own measures to mitigate, and adaptation technologies also. It may be nature based also. And most important thing is finance, or that, as I said, finance is very much important. That is also one of the hinders to use of technology and maintain the waste management system. Thank you.
Now I will answer you the question. During my empirical study in Sagar Island and Pathor Pratima, I found more than 100 families in Sagar and more than 65 families in Pathor Pratima. They have displaced from Sundarban, in especially Kudmimari district and Imlibari district, because they have the land, more than 10-20 kathas of land they have. They are producing the crops, but after the Amphan, the saline water enter into that land and become the non-fertile in nature. And right now, they don't have any way of work. What are they doing? They are selling the tea, but it is not so easy to selling tea from Sundarban to Pathor Pratima and Sagar, because already tea shops are there and they are hungering after the job. This is the reality, madam. This is the reality. But there is nothing for them, right? Till now, nothing for them. Again, I will do my empirical study in the month of January, see what's happened to them. Thank you so much for this question.
Now that you give for conclusion, I also had a question. No. One thing is, I talked of spirit of law. So in that context, spirit of negotiator, partly my question was touched, at least if not answered, by Dr. Luther Angrezi. He's just left. It was about community sovereignty. No one has talked when you are talking of environmental law. So sovereign to the 3 tiers, it has to be applicable. Just one observation. And second is that in animal welfare, when you used the terminology that humane use of animals, so it is a definitional issue, so be careful. So it should not be used. We are on one side asking for their welfare, on the other side we are putting them to slavery. So it is coexistence. So we have tied our fate with certain animals whom we domesticated when we came from nomads to settlers. And so that is why this definitional part was most important to me. And I just wanted that rolling on of definition. This will not be able to help you stabilize that concrete pillar of law on which the vertical of this Convention on Biological Diversity should go on. Thank you.
Anwarji, you have the last word. I think I have to sum up the whole thing very briefly, as I have been told. That I will begin with Meghraj, that you gave detail of India's efforts. It was very good exercise that India's policy has shifted from equity, common but differentiated responsibility, to now climate co-benefits approach. So this is the entire thing, is that no, we will do. India is of the view that if I am given more, I will do more. Okay, it is doing enough. It says that I am doing enough. It is adequate. And India is, as just one sentence, that what you would say, that the funding is, of course, it is there, that the Climate Act, the one dedicated legislation is missing from India's repertoire. Okay, so it can be, we should think seriously. Second is Monali Gandhi, yes, responsibility across generations. You covered a lot of areas, lot of issues, concerns. Yes, of course, that the responsibility across generations, that it calls on both the responsibility of states and responsibility of individuals also. And all the laws are there, all the principles are there, and those are meant to nudge in a particular direction, isn't it? But the thing is that for this thing we need a paradigm shift. Are we calculating depletion of natural resources into our gross national income or not? That is unaccounted. That is still unaccounted. That approach we must have that approach. Then we can have the responsibility across generations. Yasota Tilakratne, I liked your presentation. I think that the animals in international law necessity, you champion the cause of animals. There are laws on Convention on International Trade in Endangered Species, but its slant is different. Yours is animal welfare. Okay. Sir, Chaturvedi sir has already mentioned that in Indian Constitution it is that the compassion to living creatures. That is a national duty. It's a duty that we have to have compassion towards national creatures. And that there are case laws. You correctly mentioned that Europe has taken the initiative for animal welfare. That is something very, well, it is slightly reflected in beef hormone case and other cases also. You find these ideas are there and permeate in that case. So it's a beautiful exercise that you have done, animal welfare. Then Atul Dharmendra on loss and damage fund. It was good that the loss and damage fund. One thing that is very important in funding that I still raise and underline is that there is no mandatory source of mobilization. It depends on there is a meeting after 4 years, 5 years, it is replenished. It depends on that how much you want to contribute. There is a meeting and there is how much you want to contribute, There is no mandatory formula, like United Nations scale of assessment is not there. there is a assessment and there is that you have to pay this much. Your capacity is this and you have to pay this. This formulation this is there in the adaptation fund. There was a demand that for loss and damage fund, those who were arguing for loss and damage fund, that we must have mandatory source of mobilization. We have already suffered a loss. We need this element is completely missing in loss and damage fund, and it's going to be raised very seriously in the coming COPs. So with these remarks, I think that the Chayan, I have spoken on your aspect. So I liked all the presentations and the efforts that have gone into the making of those presentations. I appreciate the good, excellent questions raised during the deliberations. So I hope we will continue the same thing in our lunch sessions. Thank you very much.
Thank you very much for your patience and extending the session for nearly 40 minutes. And I thank all the distinguished panelists on behalf of the Indian Society of International Law. It has certainly been a very fruitful session for all of us. And let me close the session with this one sentence that I wish to share with you, is that insofar as the issue of climate change is concerned, we are all culprit and victim at the same time. Thank you, and let's enjoy our right to food.
Thank you, sir.
Let's have a group photo, please,
Sir,
with the panel.
Sir, there is a felicitation.
Okay. One of the organizers, please.
Thank you, sir. Now I request Professor Rashmi Shalpekar, ma'am, Dean, VLS, LS Vivekananda Institute of Professional Studies, to felicitate our guests.
We are not guests but hosts.
I also have one more announcement. Lunch is provided in front of this hall and as well as in front of Silver Oak Hall. Thank you.
A group photo. Let's have a group photo.
So, a very good afternoon. We welcome you to the post-lunch session on space policy in 21st century. And I also welcome you to the 10th International Law Conference organized by the Indian Society of International Law. So, we have our panelists and our chairperson here. Our chairperson is Gurbachan Singh Sachdeva sir. Sir is a renowned expert in the field of air and space law, whose expertise is drawn upon by several academic and governmental organizations. Sir has published in various reputed journals and has authored a lot of publications in the reputed international publication houses. He is currently a professor in NALSAR with his expertise in air and space law. I welcome sir officially, and I request sir to proceed with the session. Please, sir.
Thank you very much, and welcome to this session. I think we'll be one extra speaker. We'll be total perhaps 5 or 6 of us. So this is an extra one. So I suggest we take about 12 minutes each, so that we take it 1 hour, and thereafter any comments, whatever that be, or we can make 15 minutes.
I can't do mine in 12 minutes.
How long do you want?
20.
Anyway.
I'm being honest with it. I'm not going to say one more and one more.
Okay.
I'll try and not do it.
Okay. I think let's hear 15 minutes each. And we'll try and make it, because after 4 o'clock. After 4 o'clock is another session that's valedictory. So I think we better keep to the time as much as we can. And I will not get into any introductory sort of remarks, so that may now request first Nandita Nikhil Gaikwad. She'll take the first turn. Please do.
Good afternoon, Chairperson, my principal, Dr. Snehal Fadnavis ma'am, dear participant. My topic is exploration of outer space issues and challenges. There are two realms of the planet Earth. First is the ocean and the second is space above the land territory. With respect to first, that is the space, it's somewhat settled by the United Nations Convention on the Laws of the Sea. And with respect to other, that is the space, outer space, the atmospheric weather and climate, there is controversy still continues. Outer space transformed into a power frontier due to increasing space activity. The world first satellite Sputnik 1 was launched by the USSR in 1975, and this marked the beginning of the space race and provided to be the foremost reason to formulation of international space law in the following years. There are 5 main international conventions dealing with international space law: Outer Space Treaty, Rescue Agreement, Liability Convention, Registration Convention, and Moon Treaty. While each treaty has a significance, none are as quite as influential as the Outer Space Treaty and the Moon Agreement. And all these treaties have a basic outcomes, and those outcomes poses a challenge before the international community. First is common heritage of mankind. In a simple word, it is a common property of all nations used for the peaceful purposes. This principle has already been accepted in a space law under the Outer Space Treaty and the Moon Treaty. Yet, the detail of how these common heritage of mankind resources provisions of the treaty are to be made operational have not been worked out. For example, in Outer Space Treaty declares space as a province of mankind. However, it fails to resolve the conflict of interest and claims for military, non-military, aggressive and non-aggressive use of outer space as it evident from the USA, Russia and other state practices. USA, like Russia and China, never adopted the Moon Agreement and instead enacted its own legislation. In 2015, the USA became the first country to enact a national law regulating the mining of the minerals found in the outer space with a Space Act. Now, this Space Act authorized private citizens' property rights over the space resources. Private citizens likely would use these resources for personal gain instead of the betterment of the global community. The allowance of private space property rights would conflict with the outer space and the Moon Treaty's core doctrine of exploration in the interest of the common heritage of mankind. Therefore, the question is whether the USA Space Act violates the Moon Agreement. The Moon Treaty clearly states that the Moon and the other celestial bodies and its natural resources are the common heritage of mankind. Though the Moon Treaty reflects the spirit of common heritage of mankind, it fails to spell out the regime or the authority under which the resources exploitation can be undertaken for the benefit of the mankind. The second outcome is a freedom of exploration. The space exploration was inaugurated as a new era of a scientific research for the truth outside the universe. That era started with the Sputnik, and then there is a no looking back. Space mining, space tourism, and arm race in outer space continues with a greedy competition. Without any doubt, in these circumstances, it can be said that the exploration of the outer space is worrying. Some of the challenges between the international community is satellite. Satellite is initially used for the peaceful purpose, but later it may be converted for the military purposes also, and in recent year have been seen as an explosive growth in the satellite launching, and therefore satellite collision and state debris increasing. The science and technology has not only globalized knowledge and facility, but also created number of problems like regulatory issues. There is no regulation on space mining and space tourism or tourist. Ambiguous and unclear definition. What constitutes state debris? Tourism, that is not clear. Lack of international legal framework. And lastly, increasing environmental risk to not only to the outer space but also to the earth. Space tourism, space mining are also the challenges before the international community. The next outcome is sustainable development and cooperation. Sustainable development is an approach to human development without compromising the ability of the future generation and to meet their own needs and to protect planet and to ensure peace and prosperity. But the space activities spreading number of damages and violating international law. For example, there is an increasing hydrocarbon fluid launches which damage the ozone layer and change atmosphere. The next outcome is a problem of developing countries. Another important principle talked about is equitable access. Though this term is not mentioned, but the term like equality is used in Outer Space Treaty under Article 1, then equitable sharing under Article 11, Subclause 7 of the Moon Treaty, and the equitable measures in the preamble of the Liability Convention. But there is no formal mechanism to enforce these principles, and developing nation asking for the stricter and qualified international legal instrument to ensure cooperation. And last major challenge is of arms control or demilitarization of outer space. In conclusion, it can be said that the principal common heritage of mankind is the last hope of security and safety for the prosperity only when the suitable modifying, amending existing space law, new principles should be added along with taking into consideration the changing in the scientific and technological development, clarity of the word used in the act, in the international agreement, for example, space tourism, tourist, to identify the potential impact of the various space activities on the earth and its surroundings, and to prevent space debris. Exploration of outer space is welcome, but when it comes get out of the control, and that too for the self development of a state, is hazardous for humans. Future generation will hold us guilty if we fail to take positive action, solution to the various space problem, and to ensure the outer space protection. Thank you.
Thank you, Dr. Nandita, and grateful that you have finished your presentation well in time. Thank you. Thank you very much. God bless you. Fine. I think...
Okay, watch it. Okay, I appreciate that.
The comments will be made in your absence. Okay. Now the next speaker we have is Dr. Ranjana Kaul. She's
I'll
a
try
known...
my best to finish quickly.
No, take your time. Doesn't matter.
With your permission, Sachdeva.
Please do. Please do. Welcome.
Good afternoon, and I'm happy to see the number of people that are here. I see most of you are students. Is that right? And some professors, or no professors, I don't know, whichever which it is. So anyway, I address all of you who are students here and those that may not be students but professors over here. While this is all, I don't know what it is, I'm not a techie. Your PC didn't start correctly. What does that mean? Restart?
Yes.
Okay. So broadly, while this is fixing itself up, I am going to speak to you about the subject of equitable governance of space. And in that context, I am going to speak to you about space resources. But before I can do all that, I am going to take you a few steps back, rather than only focus on the Outer Space Treaty, starting with the treaty. But in order to lend you a certain context to why and how outer space came to be utilized, for what purpose it came to be utilized by the superpowers of the time, and what was really the underlying reasons why the Outer Space Treaty in the first place was necessitated in the perception of the superpowers, of course. There were only two superpowers back in the day. After the Second World War, we had the United States and you had Soviet Union. So if there's anybody operating in space, clearly they're the only ones who are operating in space. The rest of us didn't count for anything in the day. So now let this... So the starting point really of this entire narrative, the space age, the nuclear age, the civil aviation or the aviation age, and of course the United Nations are all byproducts of the Second World War. First and foremost, in 1942, the Allied advance towards Berlin was halted by this wonder weapon called the V-2 rockets. It was a guided missile, a ballistic missile, that in its cone could had sensors which could sense radio frequencies on the ground. Back in the day, people used the radio, and was accurately able to target Western capital cities. And the commanders of the Allied, we've seen a lot of American films with all these great commanders, Patton and this, that, and the other, were halted in their tracks because they'd never seen a wonder weapon like that. That was Nazi Germany. That is their gift. Now suddenly you had the Allies looking at this and saying, wow, we got to have that technology, hopefully, because in 1942, it was the Germans that had the advantage. It is only by the time we get to 1943, and as a result of the Soviet having surrounded and the victory of the Soviet army at Stalingrad, that the tide of the Second World War turned back in the favor of the Allies. Now, by April of 45, Hitler had surrendered, the Axis powers had surrendered, but Japan had not surrendered. And they were carrying on, and on the top of that, they had also gone and bombed Pearl Harbor. So reprisal was called for. And you had, in the August of 1945, the two bombs that were dropped on civilian populations of Hiroshima and Nagasaki. So welcome to the nuclear age. Meanwhile, the delta between the rocket and the military aircraft of the Second World War vintage that were flying now, obviously that altitude is enormous. And clearly there is need for the development of technology. It is obvious that there is technology to be developed. And so after the tide of the Second World War turned back to the Allies by more and more aircrafts that had been manufactured by the United States to be deployed, which were deployed in the war effort, were now sitting idle on the tarmacs in the United States. Now something had to be done with that. But more importantly was that at that time there was no international law, a definition in international law, or a definitive position in international law as to state sovereignty over airspace. And the reason why the Chicago Convention in the December of 1944, the putative victors of the war, had assembled in Chicago and written out this entire thing that we know as Chicago Convention 1944. And it determined the relationship between sovereign states. Article 1 says that the sovereign state exercises exclusive jurisdiction over its airspace. And because there was a delta in the altitude and technology had to be developed, they did not put a definitive altitude or provide a delimitation and definition of where airspace ends and where outer space begins. That situation obtains today. And now you have near space, you have space tourism. Again, so now that I've got this together, I wanted to tell you that I want to talk about equitable governance. What does that mean? When you say global governance, it requires an international organization where multiple states are members. It requires cooperation amongst those members to facilitate dialogue, to facilitate interactions, to have definitive rules of procedures, and a system of decision making with binding rules. And what is equitable governance? What is the cost benefit analysis of sharing the resources? Right? And how will those decisions be made? So I have just told you about this. Now you know the background to it. Now, following 1945, the end of the war, well, of course, after the bombs were dropped, Japan surrendered instantly. After that, US, Russia, Soviet Union established military space programs, followed in 49 by China, and so on and so forth. The only two nations that established civil space program, one was Japan, because you understand the background and the psyche of the nation, in 1969, and India in 1972. So what about the United Nations provides you that mechanism for global governance? What about the rule making? How does it work over here? एक मिनट, इसको बड़ा करते हैं? Yeah. Does it work? Is it all right?
Perfect now.
Okay.
We have kept the hourglass.
So then decision making. How does that happen? The United Nations General Assembly is the General Assembly. All members at the moment, 193 sovereign member states are the members. How are decisions made? The UNGA has 6 permanent committees. And I shall make reference only to the first committee and the fourth committee, which are relevant for the subject. At the time, there was already established the first committee, which deals with disarmament and international security. Now, after 1958, actually operational since 1959, was the fourth committee, to which the newly established Committee on the Peaceful Uses of Outer Space reports. The decisions in the committees is based on consensus. That means every single state which is a member of that committee must vote in the affirmative. One vote that is not affirmative means there is no consensus. After that adoption in the committees, it goes to the United Nations General Assembly, where the decision is by majority. So now what is it about space? So obviously the space domain, which is approximately, it's the unofficial boundary, what we call the Pontchartrain line, is internationally accepted, including by the United Nations, to be that differentiator between sovereign airspace and outer space beyond it. What else? Space resources. You cannot undertake space activities at all. Indeed, you can't undertake aviation, I suppose, without spectrum, frequencies. And then the Earth orbits, the most desirable and must-have is the geostationary orbit. Back in the day, it was because it geostationary, it moves in tandem with the Earth's rotation. And then there are planetary resources. Now, since all of us planets are parts of the moon, of course there are resources. We know, of course, exactly what we have done to our own resources, whether under international treaties and mostly under national laws. So you know what I'm talking about. Planetary resources are limited and non-renewable. Electromagnetic spectrum, the orbits, they'll always be there, but they're limited. And you must use them judiciously. The outer space treaty regime governs the outer space, the physical domain, and it provides principles to the nations for guidance on how they will undertake activities in outer space, how they will use also that physical domain. But it does not regulate spectrum, orbits, or planetary resources. Spectrum and orbital resources is governed under the International Telecommunications Union, back in the day called the International Telegraph Union. Planetary resources, although there is reference to the moon and other celestial bodies, in the Outer Space Treaty, the amplification of all that is to be found in the Moon Agreement of 79. So there are people who say that no, Moon Agreement is absolutely no good. It is uninformed. It is a valid international treaty through that mechanism of decision making. Now, the second stage of it, once a treaty has been adopted by the UNGA, is that each sovereign country will decide for itself whether it wishes to ratify it or not ratify it. And then 12 years later came Sputnik. Now, the problem was not that Sputnik was launched. The problem was that Sputnik was launched on an intercontinental ballistic missile. And this meant that at the relevant point in time, both the states were of course, they were adversaries, had advanced launch capability, standing at the opposite ends, and they were nuclear capable rivals. And this triggered a revolution in military affairs. What is to be done? Both want uncontested, unhindered access to space to develop military space technology. And simultaneously, or those who have studied history over here or international relations, you know that in simultaneous time, the world was getting divided into the Eastern Bloc and the Western Bloc. They didn't want to disturb that. They wanted to carry on those proxy wars, but keep their powder dry in outer space, because both are looking to develop. And so in 57, within weeks of Sputnik, which was I think 4th or 8th of October of 57, the two superpowers decided to approach the UN First Committee, and the first space resolution was passed in the First Committee. And here is the outcome of that. That objects through outer space shall be exclusively for peaceful purpose. Now this creative drafting, the brilliance of it, exclusively for peaceful purpose, is a euphemism for the prohibition of nuclear payloads being transported through the space trajectory. I think as a matter of default option in India, because for 50 years plus we've had only civil space program, the general understanding, including in academia and institutions, is that peaceful purpose means civil space. Therefore, outer space is for civil activity. Therefore, military activity is non-peaceful, some say illegal, and that the term exclusively for peaceful purpose is actually to be used to amplify India's position as a country that does not like conflict and war. None of it is supported by the treaty. So here's what it means. Now, this exclusively for peaceful purpose is also extended to space objects that are undertaking scientific investigation. And it lays down the foundation for the final, ultimate adoption of the Partial Test Ban Treaty, which disallows or prohibits nuclear tests and WMD tests in outer space. Now all that is fine. Disarmament ko to dekh liya, sab in place. What about military activity? Because that's what I want to do. And I have been doing. That needs to be ratified. So military activities in outer space is decided to be coterminous with peaceful purpose. So then now what does peaceful purpose mean? So peaceful purpose means I want to keep my powder dry, but I don't trust you. So anyway, we shall decide, and we decide that we will do military technology, capability, all of that, but not adversarial, not against you, me against you and you against me. But how can I trust you? That's another question. We'll come to that. And surveillance satellites are also determined to be coterminous with peaceful purpose. So these are then sealed on 17th of December when the United States launches an ICBM without a nuclear payload. So now missiles are the big thing, you know that. We have a Russia-Ukraine war going on for forever. Every day we read about missiles. And then the superpowers decided that they also now needed, having settled independent of disarmament, to discuss how these military activities will be carried out. So in 58, a resolution is passed to establish the COPIUs. And at the legal there are two subcommittees. One is a scientific and technical, the other is a legal subcommittee. All of these treaties that you're familiar with are. Now, if you look at all these treaties and look at the years, you'd have to ask yourself that on the one hand, Outer Space Treaty is all about military and how this can be done. और उसके बाद अचानक rescue agreement. I mean, what was the great importance of rescue agreement? But the point is that in the parallel, when you track the developments of this technology, by 61, Gagarin was already in space, followed by Tereshkova and the Americans. So if something happened to the chap somewhere there, then it had to be sorted out. All these treaties are being, like I said, I'll take longer. All these treaties are happening in simultaneous time. And finally, the Moon Agreement. The Americans had made a statement, President Kennedy, that before the end of the century, they'd have a man on the moon. So you needed a Moon Agreement. So then, this agreement is the only one that talks about governance and equitable sharing and balance of resources. So how do you handle the case of sovereignty? You have Article 2. I don't need to amplify that. What about the fact that I do not trust you? So what are my options here? So space activities are subject to international law and the United Nations Charter. So what do you mean by that? Article 2.4, prohibition on the use of force or threat of force in international relations. And Article 51 is the inherent right of self-defense. Then arises, so this is all about the Earth orbit and outer space. Now Article 4. From a position in 57 where the trajectory could not be used for nuclear, you now have a situation where placement of nuclear weapons in the orbit around the Earth, trajectories are now no longer prohibited for use. Around the Earth, stationing anywhere in outer space, and installation and moon and the celestial bodies. Then the moon. You do not want militarization, you do not want weaponization. So when you read that, you will understand that moon shall be exclusively for peaceful purpose. You understand what that means now. However, the use of military personnel and equipment is allowed. Then you link in military context the principle of due regard. I told you that the partial test ban treaty had been adopted in 1963. After that, both the superpowers started undertaking anti-satellite tests, direct ascent tests, without nuclear and all that. So of course it is going to produce debris. Not that they were thinking about debris, but they're thinking in terms of extraterrestrial matter. And this is the importance of that Article 9. Pursue studies in outer space and conduct exploration to avoid harmful contamination and changes in the environment of the Earth, resulting from the introduction of extraterrestrial matter, and to adopt appropriate measures for that. And what are those appropriate measures? That if you want to conduct an activity, think that it might create debris, please have international consultations prior to your test. When China was asked why it did not, it said, well, I did not have any reason to believe. Now look at the language. If it had reason to believe, I didn't have any reason to think that it would create 3,000. The Americans conducted one in 2008, said that it was all because of the leaking tank and we didn't want the environment of the Earth to be contaminated. And we said that, well, we did it at low enough so that there'd be no debris. So question arises, what about equitable governance? Well, that is in the preamble. Common interest of mankind, progress of exploration, carried out for the benefit, all of that, and international cooperation. But the preamble is not an operative part of the treaty. So how did it work? It is to the credit of Brazil that they initiated a proposal and held their vote in copious and said that unless this is included as operative, it won't happen. And so therefore, the inclusive interest of the international community was placed above the exclusive interest. And you have Article 1. All of you have read it. I don't need to read it again. But pay special attention to Para 2, the part I have marked in yellow, free for exploration and use by all states. I'll come back to that. So cost benefit. You know that later there were the principle, the broadcasting principle. What is the market value? Advanced countries will always have the advantage. And today, the market size of direct to home is 134.06 billion at the end of 24. We don't have, we know where those technologies lie and on whom we all depend. Similarly, remote sensing. The global market size of satellite EO-based services, 6.68 billion in 24. And of course, the general commercial global, sure, it has become democratized because of Article 1. But the global space economy is 603 billion. And in LEO now, because of mega satellite, 84% live satellites are operating in LEO. Of course, the United States is the frontier power. And what about the 21st century? Big power rivalry. Not only has, after the dissolution of the Soviet Union, not only has Russia become a superpower in the second term of President Putin, but you also have China that has emerged as a superpower. So nobody wants treaties, no consensus in COPUs, national laws. So what happens with equitable governance? Well, you know all about the mega satellite systems. It is even being referred to as the occupation of the low Earth orbit. There is talk of harmonizing cislunar economy with the lunar economy. This creates more difficulties. What about the new countries that have not yet come up and want to? And planetary resources, it says common heritage of mankind, which is different than province of mankind, requires an international regime when this exploitation should become feasible. And the needs for developing countries needs to be mindful. So basically, common interest and benefit sharing. Well, the United States has embarked upon the journey of national space laws, including providing private property rights to space. Artemis, an executive order under the Trump administration, has said that it does not regard outer space as a global common, and Moon Agreement is irrelevant. So you have Artemis. Now it says in the Artemis Accord only this, that the extraction of resources does not inherently constitute appropriation under Article 2.
Dr. Kaul, even 20 minutes are over.
3 minutes more.
Okay.
China, Russia, well, it is a different mechanism. Artemis is a one-way street. It's a document, you sign up, become a signatory. It's a MOU. And so they're going to do similar things, but we do not know whether it also has benefit sharing. The COPUS has a working committee. It's a rare occasion of consensus, but they are trying to put together and build consensus around it. They are seeking invitations, they're seeking submissions from states as to their views on certain aspects that they want, as well as whatever be their suggestion. And this is the present status. China has said that as far as the extraction is concerned, it relies on Article 1, Para 2, freedom of exploration and use, but doesn't say anything about the rest of the sentence. Russia says that, extraction does not give rise to ownership under Article 2, and there must be a definition of use and appropriation by you. Supports equitable ownership. China reaffirms all that, silent on benefit sharing. Japan says all that there is to say, silent on benefit. Australia is the only country that is an Artemis signatory and has ratified Moon, has said that it sees no conflict in its ability to discharge international obligations under Outer Space Treaty, Moon, and Artemis. France, like us, is a signatory to the Moon Agreement, has made very substantial suggestions, and has also, in fact, said that it should, whatever is the outcome, must incorporate certain principles of the Moon Agreement. So what do you think? Will there be consensus or conflict? Thank you very much.
Thank you, Dr. Ranjana Kaul. I wouldn't comment at this stage. No. Apologies accepted. I think with the audience here, it's all acceptable. I think now I request Shahbaz Khan to please take the podium.
With the permission of Chairperson, sir, I would like to start my presentation. My topic is Introduction to Space Security Policy. My co-speakers have already, in a very detailed manner, explained the space regime and the ethical governance issue also. Ma'am, thank you so much regarding the presentation.
So essentially, if we start with the introduction to space security policy, the initial days of the space security policy was a military usage conception of the space. Sure, the outer space has been referred as the province of mankind, which represents that no nation can claim sovereign rights over space. However, in the initial days, we have seen that this outer space has been used for military usage. For most part of the early space days, the understanding of the space security was akin to military space security. The USA and the Soviet Union embraced roles such as the use of satellite for military usage, communications, and early warnings of ballistic missile attacks. The contribution of satellites to military security of states and the maintenance of international stability and the balance of power was thought to be the only objective of space. However, that conception over a period of time has changed. Now the spacefaring nations have realized that the space safety is necessary for sustainable development and continuing benefits to be derived from space. Issues like communications for rescue, disaster management, monitoring of extreme weather conditions, improved agricultural productions have taken the concept of space usage. The aspects of space security that is prevalent nowadays includes spacecraft in orbit, the security of access to space, the contributions to the security of people on Earth, and also traffic management system in the space. And the principles which govern the space is the right to access the space and the freedom of navigation in the space. Moving on, if we see the space security policies from the angle of the international organizations that we have, which has more or less framed the policies, the very first initiative which I would like to discuss is the Conference on Disarmament in Geneva. This was done in 1979, and the discussion was on negotiation of arms control and disarmament in outer space. As you would realize, that space is not akin to a land territory in which a particular nation has territorial integrity. In June 2002, a joint paper was published titled Possible Elements for a Future International Legal Agreement on the Prevention of the Deployment of Weapons in Outer Space, the Threat or Use of Force Against Outer Space Objects. The major conclusion of the paper was only a treaty-based prohibition of the deployment of weapons in outer space and the prevention of the threat or use of force against outer space objects can eliminate the emerging threats of an arms race in outer space and ensure the security of outer space assets of all countries. This joint paper was the contributions of China, Russia, Vietnam, Indonesia, Belarus, Zimbabwe, and Syrian Arab Republic. The next contributions in the international space domain is that of the UNCOPUOS, which has been done under the United Nations Charter, which embodies the idea of collective security. As already discussed, the United Nations and the Soviet Union soon realized the immense value of the outer space for military purposes, and also they agree on certain regulations. So as ma'am has already said, that UNCOPUS works through two committees. One is the technical committee and another is the legal committee. The UNCOPUS has also come up with the United OST regulations of the 1967. Article 1 of the Outer Space Treaty itself stipulates that the space exploration is for all of the mankind and not for one group of spacefaring nations. The provision equates the obligation to jus cousins. The principle of common interest in international space law also found support in the North Sea continental shelf case. The common interest was considered customary international law, which is in sync with Article 38 of the Vienna Convention on the Law of Treaties. Even the Corfu Channel case went a bit further and held that reparation is a natural consequence of failure of compliance of international obligations. The principles of strict liability was also laid down. Moving on, the Liability Convention in its Article 2 has explained a launching state shall be absolutely liable to pay compensation for damages caused by its space objects on the surface of the earth or to aircraft in flight. Thus, this creates a concept of absolute liability within the space security policy domain. The preamble of the Outer Space Treaty also talks about peaceful purposes. I think ma'am very well explained this concept. I would just like to elaborate a bit further that the understanding of the peaceful purpose is equivalent to a non-aggressive nature of the spacefaring nations. The reason is that the Article 3 of the treaty commits parties to carry on activities in the exploration and use of outer space, including the moon and other celestial bodies, in accordance with international law, which includes the Charter of the United Nations. This would invariably mean that one has to look at the UN Charter for a more detailed definition of what constitutes peaceful purposes. Article 2, subclause 4 of the Charter obligates states to refrain from use of power. However, Article 51 of the UN Charter clearly proclaims the right of self-defense. Therefore, a harmonious construction of both the principles would mean to interpret peaceful as non-aggressive, as ma'am already said, non-adversarial. And thus it implicitly legitimizes the military use of space. However, what was particularly banned was in Article 4 of the treaty, which explicitly banned the deployment of weapons of mass destruction in space. All right. We shall also be discussing the space security policy. Since time is limited, we'll be discussing in a brief the space security policies of three nations in particular. One is USA, one is China, and one is India. The space security policy of USA starts with the NASA Act of 1958. And you would observe that the policy of USA has mellowed down over a period of years. You would see how that has happened. In 1958, the NASA Act established a civilian space program in addition to military efforts. The scuffle between USA and Soviet Union was then brought to an end during the 90s. The US space policy emphasized on commercial space and international collaboration while retaining national technical means for security-related activities. So from 1958 to 1996, you would see a mellowed down effect from military usage of outer space to a more civilian and commercial usage of outer space. In 1996, the Clinton administration released a national space policy fact sheet, which clearly attempts to balance civilian, national security, and the commercial priorities in the space arena with guidelines, including intersectoral guidelines. While it was emphasized civil efforts, it strived to establish post-Cold War guidelines for national security space. It stated that consistent with treaty obligations, the United States will develop, operate, maintain space control capabilities to ensure freedom of action in space, and if directed, deny such freedom to actions to adversaries. Further, in 2006, the National Space Policy Fact Sheet re-emphasized the national aspects of the US space policy. It specifically stated that the US would oppose any treaties limiting US activities in space that support the national interest. Another milestone of the policy was to enable unhindered US operations in and through space to defend their interests therein. In 2010, the Obama administration released the new space policy, NSP, which was largely consistent with the US space policy earlier. However, it had a different tone from the earlier policy. The tone of the policy was mellowed down. In principle, it stated to help assure the use of space for all responsible parties, consistent with self-defense, deterrence, and defeat of attacks on US and allied space systems. It also states that the US will consider arms control measures if they enhance national security, as opposed to their earlier stance of opposing legal regimes against the interest of the US. So therefore, you would observe that while USA has not completely given up its national security policy in terms of military usage, it has certainly mellowed down to include civilian usage as well. The next country in line is China. When we talk about China, we cannot skip the concept of comprehensive national power. China believes that the concept of space security is embedded within the larger context of Chinese conceptions of national security. China believes the concept of comprehensive national power while formulating national space security policies. According to China Institutes of Contemporary International Relations, which is associated to Ministry of Space Security, a comprehensive national power is the total of the powers or strengths of the country in economic, military affairs, science and technology, education, resources and influences. Space capabilities, as per China, makes a major contribution because it touches on virtually every aspect of the comprehensive national power. Therefore, the issue with China is that, first of all, it does not consider space regime to be a different set of rules and regulations. It considers space to be a comprehensive national power of itself, including other domains such as science and technology, education, resources, and influence. One of the issues within China is that it has multi-sectoral and overlapping regulations. The matters which relates to civil space activities would come under the State Council and other space-related institutions, as the former State Commission of Science and Technology and Industry for National Defense, COSTIND. It also comes under the National Bureau of Science and Technology and Industry for National Defense, BUSTIND, under the administration of the Ministry of Industry and Information Technology. The Ministry of Foreign Affairs does also play a part. The Ministry of Commerce does play a part. The Chinese Academy of Science and the State Development and Reforms Commissions also play a part. I would request a 2-minute extension, Chairperson, sir.
Please.
Thank you.
Please.
So therefore, the matters related to military space activities then are under the Chinese People Liberation Army, the General Armament Department. The non-proliferation and the export control issues relating to aerospace products are regulated by the state councils, the former COSTIND, the Ministry of Industry and Information Technology, the Ministry of Commerce, the General Armament. As already explained, all of them have a role in the space policy of China. Therefore, you would see a multi-sectoral influence of various domestic organizations within China for the space policy of China. Coming to India, we all know the journey of India in space. The Indian space program was started by the establishment of the Indian National Committee for Space Research in COSPAR in the year 1962. Subsequently, in 1963, the first rocket was launched from Thumba. From 1963 to 1965, few more important institutions came up in place: the Physical Research Laboratory, Ahmedabad, and the establishment of Experimental Satellite Communication Earth Station, also in Ahmedabad. The milestones of the formal establishment of the ISRO was set up in 15th August 1969, and also the institutionalization of the Department of Space, DOS, and the Space Commissions in May 1972. The center also went on to create space centers on a functional basis: Center for Launch Vehicle Development and Launches, Satellite Development, Payload Development, Satellite Operations and Maintenance, and for Satellite Utilization under the larger ambit of ISRO. During 1970s to 1980s, ISRO successfully implemented the Aryabhatta, Bhaskara, Rohini, and Apple satellites like the INSAT and IRS series. You would observe that, as ma'am has also pointed out, that the intention of the initial days of the space research programs was to cater to the development needs of the country. The applications includes areas such as areas of communication, information technology, education, healthcare, land water resources, agriculture, weather forecasting, meteorological developments, environment developments, and disaster management. While we have ratified some of the treaties, we are also party to some of the treaties. What is somewhat lacking from the Indian space policy regime, which was hinted by ma'am as well, is the usage of space from a military aspect. while India has been very keen to keep space free of weapons, and as a responsible nations utilize space and space applications in a long-term sustainable fashion, however, that ought not to mean that India should remain passive in wake of weaponization of space. It needs to plan safeguards, appropriate safeguards and verification for deterrent measures. Thank you.
Thank you, Mr. Shahbaz Khan. May I now request Mr. Muralidharan to please take the podium.
Thank you, sir. You're giving me ahead of Germany, right? Okay. Okay.
No,
Don't
yes,
worry.
yes.
I'll be happy.
No, it's,
Okay. Thank you, Professor. We have it here on the.
Wherever
My
you
PPT is there?
Wherever you want it.
No, I think I stand there so that I could see my time being up there.
Please.
Okay.
Your choice.
Oh, down. Okay. Page down. Where is it? Yes. It's not moving.
Yeah.
Okay. Good to see you all. To be the last speaker in the last session of an international conference is not really an enviable experience. But actually I realize the topic that I am going to talk today is very, very emotional. I wouldn't say it is controversial. When people describe their political ideology, they will say, my heart to the left, my wallet to the right, my brains right in the center. This is the ideology of everybody, okay? Now, in that you say, common heritage of mankind. What is it? Whenever we talk this subject, of course, earlier speakers also mentioned about it. I promise not to cite any treaty, and I will not discuss about any cases. An ideal recipe for putting you to sleep in a session after lunch when we have imbibed little more. That's the problem with jurisprudence, actually. All right. Now, what is this common heritage of mankind? Let's look at the Roman law or the Latin law. Terra nullius. Nobody's property. In olden days, during 1400 to 1500, somebody will go land in an uninhabited island, put the flag of the crown, and then declare, this belongs to me. This was right. I know that's what they say. Finders, if they exercise acts of sovereignty over a period of time, they will acquire title to it by virtue of the rights of prescription. 2. Terra nullius will apply to immovable property. For movable property, you have another maxim called bona vacantia, ownerless goods. For example, the fish which is in the international waters, which is beyond the 200 or 350 kilometers of exclusive economic zone. The good doesn't belong to anybody. If you go catch it and possess it, you become automatically the owner of the property. That is bona vacantia. Here, the act of first finding and getting possession is enough to get title. Now, how does it differ from common heritage of mankind? For something to qualify as common heritage of mankind, this is nothing but humanity's property. Okay? In every village, there is some property which was considered as common property actually. Everybody can use it. Nobody can make exclusive claims over that. The land which is meant for people to graze their cattle. We call it in different names in different parts of India. Nobody can claim it to be the exclusive owner, but everybody can use it actually. That is humanity's property. Now, first thing is, it is incapable of private appropriation. This is a very, very serious problem. The nearest Latin maxim which I can give, but of course I have not put it as part of the PowerPoint, res omnium comnium. This is the nearest to the common heritage of mankind. Many times I say that this maxim had some adjustment towards the passage of time and has resurfaced with the new terminology, common heritage of mankind. Number one, incapable of private appropriation. Number two, to be used for the benefit of humanity. And number three, in a sustainable manner. This is very important. There should not be reckless exploitation. I mean, in many parts of the world, Mediterranean Sea, you can't really catch a fish because there is so much of pollution that even if fish is caught, it is better to avoid it actually. But on the other hand, just above Antarctica, there are a lot of krill. But people, we are not in a position to go there, harvest it and get back. Even advanced countries like USA are giving licenses for third countries to come and fish. China takes many of them actually. To be used for the benefit of humanity in a sustainable manner. And most important, this I think is the important change. Militarization of common heritage of mankind is prohibited. Please remember, this is actually a jurisprudential shift. Under the law of the sea, as we understand it from 1600, the high seas, the area which is now controlled by International Seabed Authority, this constitutes something like 40% of the global mass. This is, I have to necessarily mention Ambassador Pardo when I talk about the common heritage of mankind. Otherwise, I haven't done my research right. And he was the person, people have been talking about it, somewhere in 1968, if I'm not mistaken, in the General Assembly resolution, not a resolution, exposition, he spoke. Ambassador Pardo spoke before the General Assembly. It doesn't really have the weight of law behind him. It's not a treaty. It's not a customary international law. I don't know, at that point of time, people would have recognized him as teachings of the highly qualified publicists, which is, of course, a subsidiary source of international law. Okay, what did he say? The area behind, the area of high sea, that is beyond the territorial sea, originally 12 nautical miles, now it has 12, right? Originally 3, now 12. Contiguous zone, originally 12 nautical mile, now it is 24. Exclusive economic zone, it didn't exist at all. Now every country is allowed to put another 320 kilometers from the base water line. And finally, in sometimes the continental shelf will jut into the high seas. In Bay of Bengal, in top part of Atlantic and other places, the continental shelf sometimes extends even beyond 320 nautical miles. In such a situation, the state will have right to the mineral resources, but it will not have the right to the living resources like fisheries, which are situated in the continental shelf. Now, please remember, the last point D says that even continental shelf, the point I am trying to tell you here is one major difference between res omnium comnium and the common heritage of mankind is that in res omnium comnium, if you want to use the space for military purposes, then international law gave the right. You remember that the renunciation on use of force is a concept that came after 1940. UN Charter, Article 2 says that war as an instrument of national policy is prohibited. So now when the CHM evolved somewhere in 1960, we were able to say, look here, this is something that you cannot use it for military purpose. Then, very important, what they say is how it will be managed. This is a very important path-breaking development in UNCLOS. I promise that I will not refer to specific provision, but let me violate it. Maybe it is 136 of the UNCLOS. Establishment of International Seabed Authority. This is very important. There is an international organization meant to exploit common heritage of mankind. No exploitation without permission or license from ISA. 3. Permission or license will have to be preceded by a signing fee, very often a couple of $1 million, which is good enough to run the institution with appropriate human resources and secretarial support. Continuing royalties depending on the quantum of use. This is very important. Then royalties and lump sum payment will be shared among, number 1, landlocked countries. Number 2, developing countries whose markets for primary commodities will either extinguish or reduce. They will also have a right to get it. And ISA can exploit areas under themselves, authority or agency. They can do it themselves. But it's an international, it's like Government of India doing business. We all know that they don't do it well, but still, because they have the monopoly, they make a lot of profits actually. All right. Now, please remember, this is one more area. This is in respect of the law of the sea. Let's look at technology. Technology today, undoubtedly, is one of the important factors in production. Karl Marx was talking about capital and labor. He didn't recognize the role of technology. 1800. This is not to say that Marx was defective, but this is to say this area had escaped his attention. And the Western countries today, they don't call them capitalist. They call themselves as social democrats. Right. Technology is one of the important common heritage of mankind. But please remember, as this UNCTAD code, you have this Article 27 of the WTO TRIPS agreement, which talks about international minimum standard, right? And it particularly says that you have to grant patents in all areas, irrespective of the area of invention. This is exactly against what Mrs. Gandhi thundered before WHO and UNESCO. She said, look here, life-saving medicines should not be subjected to patent protection because patent protection increases the cost of medical treatment. All right, I have 40 seconds. Outer space, Moon Treaty, Registration Convention, Liability and Rescue Convention, in all about 5 major multilateral treaties about which the learned speakers refer to. And merit about is that these treaties came into force within just 1 year of it opened for signature and ratification, which means international community was very, very serious in making this into a law actually. All right. Now, USA has not ratified UNCLOS. Why they have not ratified? Because they are unhappy with the common heritage. Canada, backed by the US, without taking permission from International Seabed Authority, has granted mining licenses in the Pacific coast to its own national. 3. China has claimed South China Sea. 7 dot lines or 9 dot lines. UNCLOS tribunal had said that it is a bad thing actually. Notwithstanding that, actually, opinion of the UNCLOS tribunal, China has belittled substantially the common heritage of mankind. Every big country, USA does it, Canada does it, China does it, India also should not be far behind, right? But to the merit of India, soon after COVID, Government of India wanted that vaccines, to cover COVID vaccines, must be off patent. It's an half-hearted appeal, I would say that actually, because they could have availed the powers under the Indian Patent Act to declare it off the patent. They didn't want it. They wanted to establish an international consensus, and it didn't work. China was very happy because India had all the patents in COVID. Vaccine alone, not treatment, intermediate chemicals and other aspects of it. So China was happy, but then even India suggested, okay, so let me cut the long story short. In other words, the common heritage of mankind under international law is like socialism under Indian constitution. Nobody disputes its existence here. We all speak about the preamble, and we further say that right to property is no more a fundamental right in the Indian Constitution. 3. Directive principles of the state policy tells you that means of production are not unduly monopolized by a few hands. After saying all these things, we remain unabashedly capitalistic. Okay, because we think that, we are getting slightly better. No worry, I have no problem about such psychological feel-good situations. But all what I tell you is that nobody disputes it, but nobody takes it seriously also. That's all I have got to say, ladies and gentlemen. I'm glad that you took the trouble of attending this event, and particularly the last lecture in the last session. Thank you very much.
Thank you, Mr. Muralidharan. I think everybody will share my sentiment. You've been very passionate about the subject and you presented it with heart. Thank you very much. Now may I request Ms. Jayamani to present.
Oh, she becomes the last speaker, not me.
So, a very good afternoon to everybody present here. To the chairperson, the dignitaries of the dais, and my co-panelists. I'm Jayamani. I'm a graduate student at the South Asian University, currently doing my master's in international law. And along with this, I'm actually working in my dissertation, I'm actually working on the third world approaches to international space law, with specific reference to the space resources when it comes to third world states. So in the same vein, I have today's presentation with regards to space debris. So the topic of the presentation is Beyond the Junk Blockade, the Developing World and the Right to Explore Outer Space Amidst the Space Debris Challenge. So we had our co-panelists, especially ma'am and Sir Muralidharan sir, who spoke extensively about the space law. But here I would also like to incorporate a bit of the TWAIL approach that I would be using. You can actually find the traces of TWAIL approach during my presentation, and this is also carried forward in my dissertation as well. So I'm going to talk about the asymmetry in the international law, which is systemic and which is biased against the third world states. So why are the third world states relevant here? Because we find the stark difference between the developed global north and the developing global south. It becomes more and more visible throughout with the passing day. So I would also like to borrow Nina Zwala's Professor Nina Zwala's monograph titled Capitalism as Civilization, A History of International Law. A History of International Law, where she actually takes the Marxist approach and brings in two concepts: logic of biology and logic of improvement. So logic of improvement actually talks about how after the decolonial process, how capitalism is a derivative of the colonial history, and today with the logic of improvement, the states which the developing states which were not inherently capitalistic, which when they take the capitalist approach, they become civilized. How that is being treated, that is explained in the logic of improvement. And in the logic of biology, she talks about a particular Eurocentric notion where they go by saying certain communities are devoid of civilization. So this is what she talks about. Here I would like to borrow the first logic that she brings in, the improvement, the logic of improvement. How holding on to capitalism would make you civilized or would make you a developed nation today. With this as the brief, I would like to go into the presentation, which would be about the space debris challenge today. So why space law? Why carry out space activities or allied activities? So what is the necessity for a developing nation to take up space activities? Why invest there when you have poor people to feed? This would be a question that we generally come across, but we have to understand that each of the sectors do have their own significance, and the development and the investment that you're going to put in space would actually reap out in the earth as well, be it agriculture, be it weather forecasting, disaster management, security and defense. All of these have connections with the space activities that we have invested upon. So this is about it. So the Article 1 of the Outer Space Treaty actually talks about exploration of the right to free exploration of outer space by all the states. But it also talks about another important thing, which is the province of all mankind, and they also talk about the benefit sharing province of all mankind, and they also say that it should be carried out in the interest of all the countries. So here there is a play of words rather than going and pointing towards the principle of common heritage of humankind. So you will not find the word common heritage of mankind, of humankind, in the Outer Space Treaty, but you will find the same in the Moon Treaty. So the Moon Treaty is actually it was championed by the third world states, but unfortunately it does not have many takers today. So sir actually highlighted Arvind Pardo's speech with regards to the common heritage of mankind. But this we always related to the UNCLOS, which is in the 1982. But if we look at common heritage of mankind, in the 1967 itself, the idea was brought in through the Outer Space Treaty. Later on, it was explicitly brought in the Moon Treaty as well. So why was this not successful? This was primarily not successful because of the historical imbalance in the very formation of the treaty. As ma'am highlighted, it is the legacy of the Cold War. It is because of it is a compromise between the then superpowers, the United States and USSR. So this brings us to a question: should the space domain be left to the developed states only? Should it be the prerogative of the developed states only? So not at all. So this is where we come to this concept of exploration. So every state has the right to freely explore outer space. And how does space debris connect towards it, right? So the right to freely explore outer space is actually curtailed by the amount of space debris that is present in the lower Earth orbit. The lower Earth orbit, basically after the Kármán line and everything, it is the entrance towards the outer space. And the amount of space, satellite constellations in the lower Earth orbit has been so much, it is crowded that we are not able to go beyond. So one of the phenomenon that we speak about is the Kessler syndrome. Kessler syndrome actually says that there are so many minute particles, minuscule of these particles, which are traveling at almost 200-300 kilometer pace. If a single strike of these could bring in disruptions in the space activities, and this would lead to further more collisions and further more debris, which is an endless process leading to an entire stop to the humanity's exploration of space. So this is the prime focus of it. So what actually is debris? So we have this, initially we had this dilemma as to how to define debris. Should it be according to the functional, whether a non-functional piece of space object be considered space debris, or a functional one, although does not serve the purpose that it was intended to, be considered as space debris. So initially it was through the International Law Association, which actually spoke about about this was a small discussion in the environment context, but however later on the first definition that you can see was brought in the Buenos Aires conference. Then the technical subcommittee of the corpus actually brought in the second definition, and finally today what we have is the space debris mitigation guidelines, which is a combination of both of these, and you can find that here as well. So what are the legal instruments that actually govern? So we have the Outer Space Treaty and the Liability Convention, which specifically talks about, which broadly talks about this. There are no specific instruments talking about space debris as such, other than the guidelines, which is merely recommendatory and not binding. So with regards to Outer Space Treaty, the treaty in its article says the principle of cooperation and mutual assistance must be taken care, and then with due regard principle is enshrined in this, along with the accountability to not contaminate using the harmful objects, and further appropriate measures can be adopted for consultation between the states to carry out the space activities sustainably. In the Liability Convention does not actually specifically talk about the space debris, but it talks about two kinds of liability, the fault-based liability and the absolute liability. Absolute liability is discussed in Article 2 of the Liability Convention, but it is with reference to the contamination on Earth. When it comes to the collision in outer space, it is Article 3 which talks about the fault-based liability. So depending upon the fault, the liability could be ascertained. But today, how to ascertain the liability, that particular section is missing. So primarily, what we have to focus on is the ascertainment of liability and how we can actually reduce the space debris. So with this, we actually came to the space debris mitigation guidelines. So the guidelines and certain principles. The guidelines actually give the following. First, to limit the space debris released during normal operations. Then, to minimize the potential for breakups during operational phases. 3, to limit the probability of accidental collision in the orbit. 4, to avoid intentional destruction and other harmful activities. 5, minimize potential of post-mission breakups resulting from stored energy. 6, limit the long-term presence of spacecraft and launch vehicle orbital stages in the lower Earth orbit region after the end of their mission. And finally, limit the long-term interference of spacecraft and launch vehicle orbital stages with geosynchronous Earth orbit region after the end of their mission. So these are the guidelines as such. And finally, we have the principles such as polluter pays, precautionary principle, due regard, and no harm rule, which can be incorporated in the space law domain as well, which is not currently incorporated because precautionary principle is actually considered customary international law when it comes to environmental law. You can find the stark difference when you talk about the trade law as well. The WTO does not recognize precautionary principle. It considers the trade laws lex specialis, and it goes by the WTO agreement. So finally, moving on, what is the way forward? So before that, when since I was talking about the third world, so how the common heritage, space is actually the common heritage. The first article mentions about province of the mankind, and it also talks about the right to explore outer space freely. So these are actually self-contradictory. So therefore, there should be a balance. So in one of the things that the co-panelists did not actually talk about, which I believe I can say, is the Bogota Declaration of 1976. So the Bogota Declaration was it was actually championed by the equatorial states. Sir, I would take another 2 minutes.
Yeah, take it.
Yes.
1 minute.
Yes, sir. Thank you, sir. So it was actually championed by the equatorial states. They wanted sovereignty over the geo over there, the geostationary orbit. But however, this was actually declined by the international community as such. So this actually talks about the structural difference, structural bias when it comes to the third world state. That was not even considered. So even today's law should not be biased against the third world states. So what we could do is look at what are the further solutions. One is the reusable thrusters or materials. This could be passive way to actually contain the debris. Then an active way to contain the debris is create an authority which could actually monitor space debris and actively clear space debris. But how does the authority work? We can actually borrow the concept of enterprise from the UNCLOS, where it is equitably funded by each of the states. So, and finally, there could be self-regulations brought in by the private actors. Since today, it is not state-centric. Whatever the space activities are not state-centric, but it has a lot of private actors involved in it. Therefore, provisionally, they could be regulated through their self-regulation. So, these are the few suggestions I'm suggesting here. So, with this, I would be concluding my presentation. Thank you.
Thank you, Jayamani. Now, the next speaker, which will be the last speaker of this session, is Shivani Chintala. She's not here?
She's here. Okay, you are the one.
You're Shivani.
Go ahead.
Yes. Wow, great.
Please.
Go ahead, right on.
Podium is yours. Go ahead.
Good evening, everyone. This is Srivani Chintala from VIT AP School of Law. My topic is on space warfare, lacunas in existing legal regimes, need for reforms, use of space and how it was militarized in history was already briefed by Ranjana Kaul ma'am. As ma'am already stated, space warfare is not a new issue, but its origins can be traced back to balloon reconnaissance and was notably escalated during 1950s, which again was mentioned by ma'am during when two superpowers were competing for supremacy in space. The tensions were heightened and it necessitated international cooperation to regulate space activities, leading the United Nations General Assembly to establish the Committee on the Peaceful Uses of Outer Space during the International Geophysical Year. Despite these efforts, the regulatory framework remains elusive. Even though the existing frameworks such as IHL obligations, customary international laws are also applicable in the space setting, the unique setting of the space makes it difficult for the application. Even in the OST, Article 3 specifically mentions that space should be used only for peaceful purposes. But it also states that UN Charter must be respected. Under UN Charter, in Article 51, it provides states the inherent right for the self-defense. So it may seem a little contradictory that on the one hand it says that space should be used only for the peaceful purposes, but on the other side it says that we should respect UN Charter, which provides inherent right to the states of self-defense. So the question remains that when the clash arises between UN Charter and Outer Space Treaty, which would prevail? And the fundamental principles of IHL like distinction, proportionality and military necessity are difficult to be applied in the space setting due to the increased dual usage of satellites. For example, under IHL distinction, that there should be a clear distinction between the military use and the civil use. But increasing this dual satellites, it can be used for the communication in military purposes as well as communication for civilians and use of the hospitals. Also military necessity. States by destruction of these satellites can say that this is the military necessity, but the question arises onto how much is this justifiable when it's disrupting the communication of the civilians? There were many attempts made by the states to regulate the situations, but despite the efforts made by the states, the problem still prevails. The treaties like Outer Space Treaty, Partial Ban Treaty, Anti-Ballistic Missile Treaty, which legitimized the use of intelligence gathering satellites, but it also protected the satellites. SALT 2, which never came into force, but under Article 9 of SALT 2, it prohibits the development, test of nuclear weapons or any other kind of weapons of mass destructions on the Earth's orbit. Even though it didn't come into the force, its traces can be seen in Outer Space Treaty, that is Article 4, which says that which is on the same words that the mass destruction weapons can't be used on the Earth's orbit. It mentions the Earth's orbit. So here it raises the question about how about the Outer Space Treaty? Also, during the military conflicts, when the states destroy other satellites, and there would be a debris created by these destructions. So how can states justify these destructions which affects the other states? Is it justifiable under military necessity of IHL is a question. Also, even though the Liability Convention obligates the states to take prior permission from the affecting states, would it really be possible during the conflicting situations is the other questions that would arise. Like this. So, to eradicate the problems that are arising in the space, I would like to recommend that instead of bringing the new regime for the outer space military regulation altogether, we can amend the existing laws to accommodate it to the specific settings of the outer space. With this, I would thank the organization for providing me the opportunity for this presentation.
All right. Thank you very much, Chintla. That's okay. That's perfectly fine. No problem. We have understood your point. You want some sort of amendment of laws in order to have a better control on weaponization. Understood.
Of the treaty itself.
Yeah, within that or outside.
Ma'am, not amendment as such, but there are confusions regarding the IHL regulations and space settings as to the distinction as increased dual usage of the satellites and also ASATs and such things. So I feel like the existing obligations and rules must accommodate the specific setting and increasing technology.
Wind up the session 5 minutes earlier.
You call me and talk to me some other day when you're free.
Thank you.
All right. Thank you very much. Thanks a lot.
Thank you.
Now, gentlemen, we have done with the presentations. And before I proceed further, I just read out the text of what was the subject of this particular session. It said, Space Law in the 21st Century. And it said, Charting New Paths for Outer Space Governance. Let me put the whole thing in perspective like this. We all know that we have the 5 treaties. 4 are very well accepted, and the 5th one is not accepted, which is the Moon Treaty or the Moon Agreement. All these treaties, if we look at them, they are regulatory treaties. Why I use the word regulatory treaties? They only regulate what type of activities can be undertaken in the outer space. And these have defined either permissive or prohibitive. There are permissive activities like what we call scientific exploration or peaceful uses. And prohibited are something which we can call as weaponization and militarization of outer space. This is the way this particular treaties have been done, and they have been amplified in order to bring in a little more of what exactly was there in the OST, Outer Space Treaty, which is deemed as a Grundnorm. It's a basic constitution for outer space activities. And that's where something like, I'll say, where exactly we said in the OST, astronauts are the envoys of mankind. Now, this by itself did not give enough of action activity, and it had to be brought in that they'll be received, they'll be rescued, they'll be handed over, and things like that. These were purely amplifications. Now, these treaties do not have any mechanism for correction. And today we are reaching a stage with our technological developments, like we have reached what we call is space travel and tourism. It's a reality today. Dennis is gone. Our Indian friend has gone. Many others would go. And there is a long list of aspirants who want to go to the outer space. And it's not only going to the outer space, along with that will be the tourism industry. And I'm using the word space tourism industry. And when the space tourism industry has to come, it would need some sort of residentials. It would need services. It will need workers. That sort of activity is an activity by itself. It doesn't need regulation. You have the basic sort of a thing, but what it needs is, I'll tell you more about it. Now, let me say, we have all talked about excavations in outer space. Now, excavation in outer space is becoming a reality. We have done it on the asteroids. And if it becomes a reality, then it's not a question of extracting the minerals. Then it's a question of how to regulate a lease or a regime for giving these leases for exploitation. Would it be lifetime? Would it be short time? When would be the device of that? How would we have the contracts? That is governance. And similarly, there is another parallel line coming up where people want to settle down. People want to settle down on the celestial bodies where that Mars appears more likely. But Moon is not too far. We can create conditions for living. If at all we have people going there, and as I said, we'll need workers for extraction of material, we'll need workers for giving hospitality services. No, they all have got to live. You have to have a community. And that community is going to be very heterogeneous. What you need at that stage is not merely a law. What you need is governance. There is need for. And the governance could mean anything. It could be a contractual sort of a demises. It could be leases. It could be control. It could be discipline. It could be policing. Or it could be cooperative living. So what exactly we should look forward today is not what is law. We should look forward today to a governance model. A governance model. How exactly can you have it? We may not be able to establish a governance model right on the Moon or the Mars today itself. But perhaps, as I have made earlier also, one suggestion could be that sometimes back we had the Trusteeship Council under the United Nations. The countries who were under trusteeship of that council have all liberated. The council is no more required. Why not convert or revive that trusteeship council into an outer space trusteeship council? Give them a responsibility. Create a trusteeship council with responsibility for governance and let them do it. It can be done. It may be a little difficult because negotiations at the international level are quite tricky and perhaps very laborious. But whatever be, if at all we appreciate today that what is going to happen in next 10 years, we need to look at today. We might need 5 years to have a governing council for that. So what we need as per the topic of the subject is that there should be some sort of or some form of governance. And my suggestion would be to revise the trusteeship council, convert it into outer space trusteeship council, where outer space itself, including the celestial bodies, entire domain itself becomes the trusteeship. And it tries to develop, because you need lot of infrastructure. On the celestial bodies, you need a lot of infrastructure. There'll be a lot of jurisdictional problems. And these all can't be sorted out by laws easily. You have to have some sort of a on-the-spot control organization which can do it. On the spot doesn't mean it has to exist in the space. On the spot means one which can take a decision on the spot, take control of the situation, and be the governor. That is what you need. Right. Just having clarified the basic legal issues and all that, let me go on comments one by one. And I'll try to be very brief because we are running out of time. And after that is the first one which we had was by Nandita. She talked of CHM. This has been discussed later also. As rightly said, it's a very emotional concept. And it's only a concept. To bring it down to reality is very difficult, because the psyche of each country, the psyche of people of each country is different. I may say, even within the same country, it's different. I may take the Shamlat of Punjab, which will be different than what is in Kerala. The purposes would be different. The requirement would be different. The people are different. The users are different. So what exactly we need is, CHM is a beautiful concept. But as a concept, we need to bring it to reality. And that's what needs to understand and accept the fact that outer space is nobody's land. But at the same time, by saying nobody's land, we don't mean it doesn't belong. It belongs to everyone. Everyone has a share. But that share is indivisible. You cannot take it out. I go and say, okay, this 10 tons of soil is mine. That is not the way. That is not common heritage. The next was by Dr. Ranjana Kaul, a very historical. She took us back and brought us forward. An excellent exposition. But she talked of weaponization also. And in the weaponization, she talked of the weapons orbiting the earth. Now, this is very fine. We can prohibit it. But human ingenuity doesn't end there itself. In fact, to circumvent this particular provision, the Russians developed what is called FOBS, FOBS, which is called Fractional Orbital Bombardment System. In this particular case, one satellite loaded with a weapon doesn't go around the Earth. It goes up to a certain limit, comes down, another one takes the baton and continues. And it's a fractional, so that your basic law is compromised. The basic law is that no satellite should orbit. One satellite is not orbiting. It's a different satellites, and they complete the orbit, and the weapon is still there. So the law is very important, but along with the law, yes, there was another point made by Mrs. Kaul. She talked about consultations, and she said where different countries have not consulted each other. I'll just give two examples. One is that of the United States. United States wanted to create for their communication system a dipole belt around the earth. And in order to create that dipole belt, they dropped what they had was copper needles. Millions of copper needles were spread on that. But theory was that they would spread them into a belt around the earth. But actually what happened was these jumbled into 6 blocks or 6 clusters, and millions of needles are all there right even today in the orbit. So consultations are not so easy, but we have to create and we have to build up a sort of a cooperative attitude where consultation becomes our first principle. It's in the law. Shahbaz Khan, he talked of space security and discussed of liability. But space security, the way he put it across was as a policy of a country. And he discussed India, China, United States and all that. Now, security is more related to the domain as such. And particularly where it's related is how to secure your assets. Security. That is security. In fact, to secure your assets, there can be different ways. And today, there are a lot of other methods. But way back in early of this century, I had recommended what is called space mines, based on the concept of mines which you have on the earth. Our asset is going, and the moment there is some sort of a threat, those mines take care of that, so that the actual asset is not threatened. And the mines go and destroy, divert, deflect, whatever it does. So what exactly is security? Security is primarily security of assets. Or we can have what we can say, safety from debris. Safety from debris or security of assets. Mr. Muralidharan, a very passionate speaker. And not only passionate speaker, he dealt with the subject with research. Let me put it, few people do that. Few people do that, not money. The way he put across, the way he developed the subject, and ultimately his solution, or perhaps call it as a poser, that how this can be common heritage of mankind, how the concept can be, and how it is akin to the socialism of India, is an eye-opener. We need to take a lot of... the next is...
Jayamani.
I think Jayamani. Jayamani. She talked of space debris. Now, space debris is a very wide subject. Right from the zombie sort of satellites which you have, down to even a flake of paint is also a debris. And even a flake which weighs just barely a couple of, not even ounces, much less, that can be risky also. So it's a very wide subject, and you need to work on how different sort of dysfunctional satellites, zombies, where do they go, how do they work, how do we take them to the satellite hospice or a graveyard or whatever that be. So you need to work on that sort of thing. But you tried very well. The next is
Shivani.
Shivani. Shrivani or Shivani?
Shivani.
Okay. Okay. You talked of weaponization and amending of existing laws. My opinion would be, not trying to cut shows, my opinion would be that weaponization is a process of equalization. You can't say that you stop weaponization. Russia has something, United States brings something more. Russia brings that, US will bring something else. We have also done it. I won't name it, classified information. We have also done it. Though it's not, but the fact is, this weaponization needs an understanding. It's all right in this terra, or what you call is terrestrial. It's very fine, you can do it. You fight, you are still there where you are. But when you fight in the outer space, or create the satellites dysfunctional, it's a different thing. It's an existential threat. You know, what happens is, it's not only what you're trying to destroy is a satellite, but the problem comes up, what you're trying to destroy is, it may create what we call as a Kessler effect. We call it as a Kessler effect is something, to put it more friendly term, is something like a dildo effect. You have one, you played with bricks in the childhood. You throw one brick and keeps throwing the rest of it. The dildo effect. It can happen in the outer space, and some of our orbit are so heavily dense that we cannot afford it, particularly the low Earth orbit, as Ranjana Kaul had said. Similarly, our geosynchronous orbit is terribly crowded. And there are others where there are unknown debris. So we need to be careful. And what exactly we need is a change of mind and an acceptance that outer space is very hazardous, is very risky, and it will kill us all. That's what we need to understand. And that understanding will come, perhaps gradually. You had a case of Iridium, where a Russian satellite and Iridium. Russian satellite was a dead satellite, and they collided. And US couldn't do a thing, because the fault couldn't be proved. It's a fault-based liability. So one day we'll understand, but we need to be careful. And there, in the end, I'll say weaponization is a change of mind of political thinkers and not of individuals or scientists. Thank you very much. I've finished with it.
May
Sure,
I say,
please. You say more than what you
I know that we are all very tired, and people who are listening are far more tired because it's very difficult to listen. But I just want to say to our wonderful students here, don't confuse security and safety. Security is a military concept. It means the protection of the sovereign state and its assets against intentional threat and attack.
Yes.
Safety is the protection or to assuring the safety of your national space assets against unintentional threat of man-made space debris. Don't crisscross the two for those that are. That's part one. Part two is that don't confuse international treaties that prohibit or limit nuclear, which are UN treaties, from bilateral treaties between the United States and Soviet Union. It is precisely because of those bilateral treaties. You referred to SALT and START and all of those. Those are bilateral treaties. They were not negotiated under UN. They didn't want to reveal their weapon systems. But it's precisely because of that, together with surveillance satellites, that prevented a third world war until the end of the dissolution of the Soviet Union. Today you have three superpowers. None of those guardrails are existing today excepting one between Russia and USA, which will end in February 2026. That pertains to tactical nuclear weapons. In the ongoing conflict in the Ukraine, the Russians have moved their tactical weapons into Belarus. Space is geopolitics. Everything that happens there starts and ends here. So if you're talking of war in outer space, you're talking in outer space, where your orbits are now free for use, whether a nuclear hit. Look at the ICJ advisory opinion on that. An opinion was sought from the International Court of Justice as to the legality and whether there is now a binding rule in international law which prohibits the use of nuclear weapons. The ICJ, the full quorum, studied all the treaties in public international law, bilateral treaties and other instruments, and arrived at the conclusion that not one single international treaty or bilateral treaty unequivocally prohibits the use of nuclear weapons. And therefore, if the existence of a state, that state feels that its very existence is threatened, it has the right to use such means as it wishes to. So when you're talking about nuclear strike, it's not happening in space, it's simply being transported over here. That had been prohibited in 1957, but the development of technology has now resulted only around the orbit. And all these weapon systems like FOB that Sachdeva Saab was talking about, the fractional orbital bombardment system, is all part of the weaponry that the two superpowers had, which they were supposed to have destroyed, but China has apparently developed exactly that. When you see a black and white picture of Yuri Gagarin's spacecraft landing on the Earth. Otherwise, they drop into the sea and they're taken out, right? Landing on the Earth in 1961, the Russians already had developed that technology. Recently, there was a picture in the newspaper of the Chinese taikonaut arriving on the Earth. It's telling you that you can land exactly where you want to on a point of that. Every country will develop that weapon system, those that are advanced enough. This is a very dynamic, don't crisscross between the two. Thank you.
Including Elon Musk, who got back the...
Now, Elon Musk, firstly, is providing a dual-use satellite system. He can't do it on his own. Under Article 6, is authorized by the state. Number one. Everybody will find it cheaper to build dual-use satellite systems. It's so much cheaper, right? And you cannot apply कि वो इस transponder को कैसे मारना है तो उसको laws of armed conflict. You cannot. It's very difficult. And second of all, the chap appears to have taken a billionaire and had a private spacewalk. NASA is quiet. They do not want to say that they had anything to do with it. And US FAA in any event not authorized to allow it. So private activities by private operator without state sanction is a very concerning thing in Earth orbit. It's already happening in outer space, on the moon. Thanks.
So,
thank you very much. Thank you everyone for bearing with us. Good luck and thanks.
Thank you everyone. With this, we come to the end of the 10th International Conference organized by the Indian Society of International Law. So, I thank the chairperson and the panelists. Now I request Professor G.V. Rao sir, the Vice President of Indian Society of International Law, to felicitate our